Yes, but it's my applications, but two under sections 34 and the other under sections 36. For stay of the award. Now, on the last occasion, they had filed an application where they had disclosed certain documents. This is an application where we had challenging an award of a former district judge, where we had taken a lot of points of documents being manufactured, and fraud was one of the grounds taken in section 36 also. Now, they have disclosed certain documents, and I am in respect of a company whose management has changed. Now I'm appearing for Shrey though, but it has been taken over by Narset. So we after taking one extension have prepared one affidavit in opposition to the applications filed by them GA1 in both the AP 529 and 530. We are in default to. Oh, अच्छा operated. Thank you. So opposition, yes. Yes, but only we are out of time, I have to admit. I'll accept that. I'll tell you, Lordship, one thing, which is a mistake on our part. If your Lordship kindly gives me leave to correct that, if your Lordship kindly takes page 13 of any of the affidavits, if your Lordship kindly takes page 13 of 520 AP 529 of 2024, the opposition that I have just filed. 13. Yes, page 13. Yes. Paragraph 16, if your Lordship kindly turns to. Yes. The last sentence, upon inquiries, it has transpired that the said mobile number is of one Ravi Agarwal, who was again on notice period, or a notice period is there. If your Lordship kindly permits me, my advocate record will sign, if your Lordship permits me, a notice period, if it can be deleted.
We'll read it as on.
No, because affidavit you cannot do it without your client.
Yes,
So we'll
read it as
this.
yes.
We'll write a letter to that effect then, in that event. Because
we are here. Well, we had to file a reply.
Notice period should go.
Our notice period should the 3 months.
Yes,
That's 3 months.
I was supposed to file a reply. They're out of time. They served us day before yesterday, my lord. This was on extension. Lordship grants me 2 weeks time, my lord. I'd taken 2 weeks time previously as well, my lord. Kindly keeps it after vacation whenever it's convenient, your lordship.
The affidavit in opposition, the affidavits in opposition filed in respect of GA1 of 2025 in APCOM 529 of 2024 and APCOM 530 of 2024 respectively be kept on record. First up, the delay in filing the same is condoned and the affidavits are accepted. Next para, the time for filing replies thereto is extended for a fortnight from date. Push up, the matter shall next be listed on January 9, 2025 under the same heading.
Grateful.
I'm grateful. Supplementary body. No, they'll read it according. They'll say that they'll read it according.
Who read?
By a letter, at least we may communicate.
Yes, we suppose you may or may not know different. We will overlook that.
Great.
Your Lordship, I'm appearing for the respondent in 5 and petitioner for 6. Your Lordship, Mr. Chadda is on his legs. If Your Lordship pleases to grant a short passover.
Passover means nothing, I mean, because we have only one other matter.
I will also seek for time on the ground of Mr. Shatto Banerjee. He is unwell. He could not come to court. In the previous occasion.
To wait for Mr. Chadda. At a very well Passover, let us call 7 and do whatever.
Your Lordship, I appear on behalf of the Kessel's engineering, Your Lordship.
Yes, we have passed over 6. 7 is
5 and 6.
Yes.
Item number 7, my lord, I am for the petitioner, my lord.
Yes.
My lord, we have challenged, my lord, an order passed by the review committee of willful defaulter committee. My lord.
Yes.
Initially, an order of injunction was passed from giving effect this order, which is still subsisting. My lord, I am on same prayer, my lord. I am led by Mr. Banerjee, my lord. He's just informed me over phone that he's unwell, my lord.
Well, on the prayer of the petitioner, the matter is adjourned till December 19, 2025. পাসওয়ার্ডটা ডাকো, পেপারস গুলো দেখি তো। You start the matter.
Your Lordship, I am not equipped. It's just Your Lordship gives me 3 minutes, Your Lordship. He's on his way.
You are waiting. এটা ভলিউম 2 কেন? আর ভলিউম 1 কত? আচ্ছা আচ্ছা, ঠিক আছে, দরকার নেই। এটা এটা
Your Lordship, Mr. Chadda just informed it will take him another 15-20 minutes. In that case, Your Lordship, would it be Your Lordship's pleasure?
then the list will fall. I mean, it should start the matter. Someone should be there who should start the matter.
Your Lordship, can
It's
it
not
be
done.
on to next week?
We'll close arguments then. Sorry. Cannot do it indefinitely, we cannot do it. Because the appellate side list will also collapse then. You should have at least prepared yourself. Preliminary preparation should be there, since you are asking for time. Who is the advocate on record? Which?
Rishabh Dutt Sharma from Sharma and Sharma.
Where is he? Where are they?
He is also on his legs, Your Lordship.
Very good. Excellent. You can close arguments on this then. No use keeping it pending. You knew that you had to start today. Somebody else should be there, please, ma'am. Call somebody who should start. Mr. Chadha, we cannot wait for Mr. Chadha only. এর কোনো অপোজিশন আছে দেখো তো দেখি কি কেস মেকআপ
My lord, may I please offer, my lord, my most sincere apologies. My lord, my lord, start making my submissions, my lord, online.
do that
I
please
apo-
do that
I
Mr. Chadha,
apologize.
do that when you reach near the court then
My lord, I once again, my lord, apologize most
No difficulty.
profusely. I'm
No difficulty.
extremely sorry, my lord.
yes Mr. Chadha, we start the matter and when you reach near
My
the
lord,
court,
I am
we'll shoot for
deeply
a minute like
ashamed.
that.
I am deeply ashamed. I apologize, my lord.
No difficulty, please start.
My lord, the primary challenge raised, my lord, by the petitioner,
Yes,
if I may, my lord, split, my lord, the arguments into two, my lord, categories.
yes,
The first category, my lord, is with respect to, my lord, the making of the award. Under that, my lord, two primary grounds have been alleged. The first, my lord, being that, my lord, the award was, my lord, vitiated by fraud. To show this, my lord, they have attempted to state that the learned presiding arbitrator suffered 2 stints of hospitalization, the second of which ended merely 2 days before the passing of the award. The second ground under the aspect of the challenge with respect to the making of the award is with respect to, my lord, section 31, subsection 2 of the Arbitration and Conciliation Act.
yes,
They argue, my lord, that the award ought to have been signed by all 3 of the arbitrators. And in the event it was not signed by all the 3 arbitrators, the reasons ought to be stated. My lord, may I first deal with, my lord, the first aspect, my lord, which is with respect to fraud. I hope I am audible, my lord. My lord, am I audible? I apologize.
yes, you are.
I apologize. My lord, as I had indicated, the argument of the petitioner was that the presiding arbitrator was not in a state to have delivered, written, or decided on the award on account of his hospitalization. My lord, in brief, there are, my lord, 4 dates that they have relied primarily to show this. The first, my lord, is the first period of hospitalization, which ran, my lord, according to them, from the 25th of April 2020 to, my lord, the 28th of May 2020.
Yes,
They then submit, my lord, that the written note, my lord, of the claimant therein, which is the respondent herein, was filed on the 11th of June 2020. They submit that shortly thereafter, on the 14th of June 2020, once again, the presiding arbitrator unfortunately suffered a subsequent stint of hospitalization. This stint continued, my lord, until the 20th of July 2020. The award was passed on the 22nd of July 2020. The second limb to their argument here is that the hospital records would evince or show that not only was it a stint of hospitalization, there was, quote unquote, a state of altered mentation on behalf of the presiding arbitrator.
yes,
This they showed, my lord, by relying on the discharge certificate of the first stint of hospitalization. My lord, at the very outset, I must say this, my lord. The entire case on fraud here is based on suppositions, assumptions, and presuppositions. Why do I say this, my lord? And what are these assumptions and presuppositions and surmises? The first that the award was written only after the second discharge. Only in that circumstance would it be a ludicrous thought or argument or statement to say that a 120-page award was passed 2 days after his discharge from hospital. My lord, one of the reasons for such assumption, which is in fact a further assumption, is that it is a generally accepted practice. A generally accepted practice for an award or a judgment to have it to be written only after the written notes of arguments of parties are submitted. They therefore rely on us having submitted our written notes of arguments on the 11th of June and his second stint having started on the 14th. This is the first assumption. This is the first surmise. This is the first presupposition. The second, the award is dictated in first person. First person being the first person of the presiding arbitrator. The argument is therefore that it could not have been any contribution, or at least that is what is trying to be made out of second arbitrator who joined in the majority. I will deal with all of these points later, but here may I just say this. At worst, my lord, it may be a quirk of language, nothing proven. Second presupposition. The third presupposition is that prior to the written notes of arguments being submitted, or prior to the writing of the award, there were no discussions between the arbitrators. There was no deliberation by the presiding arbitrator himself. No sort of a thought that has gone into what the decision would be prior to the purported writing of the award after the second discharge. All of these above are insufficient to establish fraud. That's number one. Number two, all of the above are assumptions, presuppositions, and conjectures. Once again, when it comes to establishing fraud, such facts, such conjectures cannot be taken into record. These were the dates primarily relied on by them. With my lord's leave, may I rely on certain other, I'd say, crucial facts, which would in fact establish from the facts of the case that no case for fraud has been made out. May I, my lord?
Yes.
The first date is the 18th of January 2020. This, my lord, is the last date of hearing. Incidentally, my lord, it is the 89th sitting of the tribunal. So if I may say so, the learned tribunal had fairly long time to mull over the facts, to mull over the issues, and to mull over the argument. First fact. Second fact, man. On the 10th of June 2020, the petitioners sent their stamp paper per the request of the tribunal. I will show where I'm getting these dates from the award itself. My lord may just allow me to place the other dates before I show my lord where I'm getting these dates from, if I may please. On the 17th of June 2020, my lord, the petitioner hearing, the respondent before the tribunal, purchased the stamping. This date is crucial. My lord may note this date is after the second stint of hospitalization began.
Yes.
on. Yes, my lord, fourth date. On the 6th of July 2020, the learned respondents sent, my lord, the stamp paper that they purchased on, my lord, the 17th of June to the learned tribunal. Both of these dates, my lord, when they sent the stamp paper, were during the period of hospitalization of, may I, my lord, now, may I, my lord, now take my lord, my lord, to the relevant portion
One
of, my
minute,
lord, the award.
1 minute, Mr. Chadha. The
My
10th
lord,
of
my
June
lord.
2020. What happened? 10th of June?
10th of June 2020, my lord, the respondent herein, the claimant before the arbitrator sent their stamp paper. My lord, both parties were, my lord, required and requested
Yes,
to
yes.
send stamp papers.
Yes.
The petitioner sent it on the 10th of June. The respondent, I'll my
Petitioner
lord,
or
say claimant
respondent?
sent
Who
it on.
sent?
My
Claimant.
lord, the claimant. I'll say claimant, my lord, claimant sent. Who is the respondent here?
Yes.
The claimant, yes. May I have my lord's leave to refer, my lord, to it as neo-metallics? I think, you know, that might clear some confusion, as my lord pleases.
And 17th June, who purchased?
17 June, the
Present
respondent before the tribunal, being the petitioner, present petitioner, my lord.
And
Kessel.
they
If I
sent
may
this,
have my lord's leave to
and,
refer to
and
them
it
as
is
Kessel.
it is they who sent the stamp paper on
You
6th
know,
of
they sent
6th of July.
on July, my lord.
Correct.
6th of July.
Right.
My lord, yeah, great. My lord, if my lord may be pleased to take the award.
Yeah. Out of-
My lord, this is my lord, from, my lord, my lord is referring to it from the supplementary affidavit, my lord, or my lord, the section 36 petition.
Supplementary affidavit, কোনোটা
My lord, I do not want to interfere with what my lord has marked. My lord,
Yes, I'll just check that.
my lord.
আমার ফ্ল্যাপ লাগানো আছে এটাতে না দুটোতে জিতে দেখো অ্যাওয়ার্ডটা অ্যাওয়ার্ড এখানে কোথায় এটা অ্যাওয়ার্ড নয় অ্যাওয়ার্ডটা কোথায় অ্যাওয়ার্ড পাস হয়েছে
My lord, perhaps my lord is referring to it from the section 36 petition, in which case my lord may kindly take volume 1 of that petition. Subject to correction, my lord had marked it perhaps from them.
Just check.
My lord.
No, I didn't.
Then my
Oh,
lord
not
may
actually,
kindly
yes.
take the supplementary affidavit.
Very- What is the page number, Mr.
My
Chan?
lord, my lord may kindly take volume 6. You know, the page number would be 708.
Yes. Please come to the supplement. Yes.
My lord may kindly, my lord, take internal page 4, my lord, in case, which is running page 714, my lord.
Right.
My lord, may I apologize to my lord, my lord, I have reached the
You have reached. Wait for 5 minutes and come
My
here.
lord, my lord, I will run it. I once again, my lord, tender my
No
deepest
difficulty. Yeah,
apologies. My lord.
just switch off and come here. Yes.
My lord, I'm running. Lord, once again.
Yes.
Lord, I
You
accept
came
my-
very fast. Yes.
Lord, I'm no excuses. Lord.
I hope you didn't run up the stairs.
Lord, I had to. Lord. I have already
Take your breath. Take your breath.
If my Lord has, my Lord, page 740.
Take your breath.
My Lord. Prior to that, if my Lord may refer to the previous page, my Lord may note the stamp
17 June.
17 June. This is, my Lord, purchased by HSA advocates, the advocates on record of, my Lord, the petitioner here. This is where I get the date 17 June. The remainder of the dates. My Lord may kindly take pages 714. May I place this entire page? After completion of witness action.
I've actually read it, Mr. Chadha. If you want to say something, you
Miller,
can
just
you want to stress certain portions.
certain points. Miller, it is extremely important. Miller, it belies the entire case. I will show my. First,
Take your breath, please, Mr.
my Lord.
1 minute break.
I'm deeply embarrassed. Now, just to indicate, I'm led by Mr. Bagh. Just to indicate, I'm not. In case he comes learning. My Lord may take the second line.
Yes.
The claimant's counsel has argued from the 51st sitting to 66 sittings. This ended on the 20th of April 2018. Whereas respondent's counsel commenced from 67th sitting, 14 June 2018 to 85th sitting, 16 September 2019. Claimant gave reply from such and such date, 89th sitting, my Lord may note, 18th of January 2020. That was the last sitting.
So he had 3 months before the hospitalization after the last
3 months.
conclusion of hearing.
Not only that, my Lord may kindly take me of the next paragraph. It's a crucial point. The notes of entire argument of the parties has been taken out by the stenographer. And copies of such recorded notes had been forwarded to the respective parties. The minutes of each sitting were also forwarded to the parties. What was the presupposition, my Lord? Presupposition was, until written notes of argument come, award would not have been written. It could not have started writing it. I submit, my Lord, every argument was recorded. And with my Lord's leave, I will later place a few of those minutes. Not only were arguments, my Lord, recorded of the parties, but the tribunal had, my Lord, recorded its prima facie observations in almost each of those minutes. So, my Lord, this belies also, my Lord, the third presupposition. That, my Lord, prior to the commencement of writing, there was no deliberation, whether between each other or, my Lord, within himself, in coming to a conclusion, in mulling over the arguments. Therefore, my Lord, now, my Lord, may take the last paragraph, my Lord. At the last sitting of the proceedings, on the 18th of January 2022, parties had wished to file their respective notes of argument. This is not, my Lord, in fact, even a direction from the tribunal. It's the parties who wish to, my Lord, that's the recording. The respondent had filed their notes on my Lord, I've placed those dates, 28th February 2020. My Lord, the respondent herein filed it subsequently, my Lord, 11th of June. My Lord, may kindly take the third, my Lord, the third line from the bottom. The parties were directed to provide necessary stamp paper for delivery of the award. Claimant sent stamp paper by its advocate's letter dated 10 June 2020, whereas respondents had sent it on 6 July. That is where I got those dates. Now, my Lord, My lord may note first, my lord, the extent of time the arguments, my lord, went on for. I had already submitted, my lord, plenty of time to mull over, plenty of time to, my lord, begin deliberation. Not saying, my lord, that they ought to have come to a rigid conclusion. But the process, my lord, could have started much before the 11th of June. And it would have. Next, my lord, substantive arguments were finished, in fact, on the 9th of December. In January, all that happened were, my lord, 2 days for the respondent herein to reply. Third, my lord, all arguments were recorded. My lord, may I now trouble my lords, my lord, with a few of these, my lord, recorded notes. If my lord may be pleased to take the second volume of the supplementary affidavit at page 265.
Yes.
My lord, this was, my lord, the first, my lord, first sitting wherein the petitioners herein, my lord, made this submission. I'll at this time not trouble my lord with the submission. I will trouble my lord or my learned senior will when it comes to the merits. My lord may take page 266, middle of the paragraph. Learned tribunal puts a question whether this rectification was necessary.
No, this was the claimant who was arguing. You.
No,
Them.
my lord, the respondent therein, petitioner here.
All right.
May I, my lord, refer to them as Kessel, which my lord.
Better. You are neometallics?
Neometallics, they are Kessels, my lord.
Right.
Perhaps it will avoid confusion.
Yes. Yeah.
Grateful, my lord. My lord may now take the next page, the first paragraph. And here, if I may digress slightly, but my lord, only digressing to the next argument, my lord may note that it is not two members of the tribunal making this noting, my lord, is all. If my lord has page 267, the first paragraph. On the views of the tribunal, whether the claimant has a contributing factor for these issues, he submits such and such. Then my lord may skip a paragraph and come to the third paragraph. The tribunal observed that once defective, there is no enlargement of time. If you accept the complaint and act upon, what will be the consequence? My lord may then, my lord, the next sitting starts at 268. My lord may take page 269, the last paragraph. The learned tribunal, if I may please, if my lord has it. The learned tribunal observes that there was no complaint with regard to the overloading. The complaint is minimum loading. What was the defect and what was the extent of the defect? There is a breach of implied terms, either warranty or condition. Was it mercantile quality? My lord may again skip one paragraph. Paragraph after, the learned tribunal observes that the machine did not function according to the capacity. This is the extent to which, my lord, the tribunal has, my lord, deliberated.
But Mr. Chadha,
My lord.
expression of, asking questions or deliberation during the arguments, we repeatedly ask questions. That does not mean it has anything to do with the final.
My lord, why I submitted this?
Tribunal, yes, it
is making
participated as a whole.
It is making observations and putting parties to notice. In fact, my lord, I submit that this shows deliberation had begun well before written notes of argument. That is all I'm trying to show to my lord. My lord, the impression given, my lord, in the section.
But deliberations during arguments cannot substitute deliberations post-argument.
Of course not.
Because during arguments, many things evolve and
of course
our
not.
opinions change every day.
Of course not, my lord. All I say is this, my lord. When such observations are being made, did the tribunal have any written notes before they came to any sort of conclusion? Was it a requirement? Was it, my lord, at all necessary for them to start writing an award, the written notes? It is evident that arguments are being followed. Arguments are being made and recorded. They are already on paper.
That is very important because the entire arguments were also sent to them, sent to both parties.
Exactly, my lord.
That is very important, yes.
I'm grateful. I'm deeply grateful. That is it. That is, my lord, the point.
So they had this immediately after the hearing was over, last hearing.
My lord,
They had the entire
may
thing
not be
suggested.
immediately, my lord, maybe a short delay, but definitely not the delay of 11th of June. Definitely not that much. Maybe 2 or 3 days, as long as the stenographer took. This was the stenographer in real time, my lord, recording submission.
Yes.
And in fact, my lord may, for example, take the paragraph after. Each paragraph being placed is being noted. Which number? This is the detail with which these notes were being made. I submit, my lord, then a 5-page, my lord, a 6-page written notes of arguments, which could very well have been not something that was argued, because that quite often happens. What will, the tribunal rely on? A real-time actual recording of submission, or a post facto, my lord, written notes of argument, which, my lord, probably our default, my lord, Neo, my lord, submitted it 6 months almost after, my lord, hearing concluded. I submit, my lord, there was no requirement and they would not have waited that long to start writing there. What would have gone out of the mind? Would have started writing perhaps immediately. And definitely no basis to say that the written notes of arguments were required. Now, my lord, I submit this. Allegations have been made, my lord, regarding the presiding arbitrator. Lord, I will not, my lord, make any. All I say is this: when were these allegations made? When the 34 was filed? When was his first hospitalization, my lord? His first hospitalization was, my lord, on the 25th of April 2020. Nothing then. Now, my lord, last date of hearing, 18 January 2020. Any allegations of unfitness? No. My lord, when the stamp paper, when, my lord, they submitted, Kessel submitted their written notes on the 18th of February. Any allegations of unfitness? No. On the 17th of June, when they purchased the stamp paper while he was in hospital. Any allegations of unfitness? No. When, my lord, they sent it on, my lord, the 6th of July 2020. Any allegations of unfitness? No.
6th of July, he was in hospital.
My lord, 17th of June also he was in the hospital.
Yes.
When they purchased it.
Yes, but they must have anticipated that after hospitalization, he would take some time to deliver the judgment. I mean, how could they know that he will be, the judgment award will come up within 2 days from his
ready,
release?
my lord, before. Not only that, and my lord, I'll show, my lord, the documents they relied on subsequently. They show nothing. I'll show it, my lord. However, all I say is no allegations. And, my lord, most importantly, my lord may note that the award was passed on the 22nd of July. That wasn't the end of proceeding. We filed an application for amendment, my lord. My lord may note that date. My lord may note. We filed it, my lord. Decision taken, my lord, on the next year, my lord. So I apologize, my lord. Application filed, my lord, on the 21st of December 2020. Decision, my lord, on the 22nd of February 2021. Was this decision ex parte? No. May I show this, my lord, with my lord's leave?
No, the award was dated when?
My lord,
22nd of July.
Of July 2020.
20, yes.
My lord, on the 21st of December 2020.
Yes.
I, my lord, filed my application under section 33 for amendment.
All right.
Well, my lord, it's correction. It wasn't. It was for correction and it became an amended award. My lord, may I place that? I think.
When was that? When was
my lord, it was decided, my lord.
Yes.
On the 22nd of February 2021. That is, my lord, what I, with my lord's leave, would like to place. If my lord may have, my lord, the first volume of the section 34. 34 petition is first volume.
GA. Yes.
My lord may kindly take page 45. Incidentally, my lord, the main award was not annexed here. And that's of some import in my lord, second leg of arguments. I'll show it. My lord may in fact keep this wall. My lord may take page 45. My lord.
Yes.
This is the letter, my lord, dated 22nd of February 2021.
Yes.
Containing, my lord, the amendment to the award, which now becomes the amendment. My lord has it. My lord may note the date. My lord may also note here, my lord, it was copied, my lord, to the dissenting arbitrator. I won't trouble you with that page again. However, my lord may take the next page. In fact, my lord may kindly come to page 47. My lord may take the second paragraph. My lord, I may put my lord perhaps on notice. I will trouble my lord with this again. My lord may not fault me for showing, but in the subsequent argument, my lord may take the second paragraph at page 47. On or about 21st December 2020, the claimants had filed an application under section 33 of the Arbitration and Conciliation Act, inter alia, praying for the following order. An order be passed amending the award dated 22nd July 2020 in a manner as indicated in paragraph 6 herein below. B. Such other order or orders and or directions as this learned arbitral tribunal may deem fit and proper in the circumstances of the case. Next paragraph. The first sitting of the present application was held on the 18th of January 2021, wherein, pursuant to a prayer from the respondent's advocate, Milord Kessel's advocate, a direction was passed to file affidavit in opposition by the respondent by 26 January 2021, and affidavit in reply, if any, to be filed by the claimant Neometallics on or before 29 January 2021, when hearing of the said Section 33 application was fixed. On 29 January 2021, as per earlier notice, the hearing took place virtually. The respondent Kessel chooses not to file any affidavit in opposition to the said Section 33 application. It was submitted by Mr. Ghosh, learned advocate of the respondent, Kessel, that the respondent, Kessel, does not wish to file any affidavit in the present application, as the amendment as sought for of the award dated 22nd July 2020 was very formal. It was accordingly submitted by Mr. Ghosh that his client does not have any objection in allowing the application for the relief as prayed for before. And Milord, the reliefs we prayed for was subsequently granted. Once again, on 26 January, I apologize, Milord. On 18 January 2021, no objection as to the unfitness of the presiding officer. On 29th January 2021, second time they are appearing. No objection as to unfitness. Now suddenly, they have decided that he was mentally in an altered state, unfit to deliberate and write an award, and therefore, based on these surmises, this award, Milord, is vitiated by fraud or corruption. Mere surmises, mere conjecture. No objection whatsoever raised before. Now, my lord, even though I say these are conjectures, let me meet their point head on. They say altered mentation, altered mental state. How do they say so? My lord, they rely on a discharge sum. Incidentally, my lord, if my lord may kindly note the pleadings, two places where the pleadings come in. My lord, one ground in this regard is in the Section 34 petition. My lord may note it is ground 4 at, my lord, pages 19 to 20 of the section 34. My lord already has that volume in front of my lord.
Pages?
My lord, 19 to 20.
Yes.
May I place that paragraph, my lord? And my lord, may I then point out a huge lacunae in that pleading? Pleading, my lord, if fraud is alleged, my lord, established principle has to be proved, has to be pleaded as well, full particulars. Now, my lord, they state these, I'll place it. For that, the impugned award has been passed, nullified against the petitioner herein, inasmuch as the presiding arbitrator was admitted in the hospital, excuse me, my lord, until 20th July 2020, an alleged majority award has been passed on 22nd July. The presiding arbitrator was initially admitted in the hospital for a period of 1 month and 3 days, spanning from 25th April till 28th May. The presiding arbitrator was again readmitted in the hospital for a period of such and such. I will not trouble my lord. My lord may come to 2 lines ahead, which is just 48 hours before the signing of the alleged majority award. Signing, not writing. Out of the above period of hospitalization, the presiding arbitrator was put on the ventilator and was in ICU for a substantial period of time. The presiding arbitrator was suffering from cardiac arrest. My lord may note cardiac arrest, my lord, because this is a modus operandi, my lord, of the petitioners. Yeah, I'll show that next. Cardiac arrest, I'll show that. Unsuccessful before, and my lord, I submit unsuccessful here as well, hopefully, subject to my lord. Parkinson's disease, COVID-related complications, severe urinary tract infection, severe lower respiratory tract infection with a tube inserted in the trachea, and several other illnesses. It is humanly impossible that the presiding arbitrator with all these ailments and with the advice of the doctors to take complete bed rest and within 1 day of being discharged was able to write and sign the award running into 120 pages. It is thus evident that the award has not been prepared by the presiding arbitrator. And all the conjectures which I gave, my lord, are here. And one lacunae, which I'll place, my lord, after showing the pleading from the supplementary affidavit, which is where the documents suddenly come in. My lord may take the first volume of the supplementary affidavit. My lord may kindly take paragraph 3. If I may have my lord's leave for 1 second.
Yes.
My lord may take page 3, paragraph 3.
Yes.
The presiding arbitrator was hospitalized initially for a period of 1 month and 3 days, spanning such and such. The presiding arbitrator was again readmitted for a period of such and such, which is just about 48 hours before the signing of the alleged majority award. Out of the above period of hospitalization, the presiding arbitrator was put on ventilator and was in ICU for a substantial period of time. Presiding arbitrator was suffering from cardiac arrest, such and such, I will not repeat. Now, last sentence, my lord may come. Second, from the bottom of this paragraph, copies of his medical reports are annexed here too and marked as Annexure A.
Yes.
My lord may consider both of these pleadings. So the sum total of, my lord, his proof, quote and quote, my lord, what he says is proof of, my lord, the fraud. When did he come to know of it? No pleading. Why isn't there one, my lord? He could have and ought to have objected to hospitalization before. And my lord may not take this as a main point or not a primary point I'm arguing. These are medical records. How has he come in possession of them? One, how has he come in possession, my lord? Here, my lord may not take me amiss, my lord, but allegations are being made against an individual, a presiding arbitrator. Has he, my lord, had an opportunity? Unfortunately, now, my lord, the presiding arbitrator is no longer with us. But there was this matter was filed, my lord, far back. Opportunity ought to have, my lord, been called for. And here, in fact, if my lord may allow me to come back to the medical record subsequently. Here, my lord, the modus operandi comes into play. They have attempted this very, my lord, tactic before in these proceedings with respect to the previous arbitrator. There have been several learned arbitrators who have passed through the 89 sittings, a vast period. This went before the Delhi High Court. My lord, may kindly take volume 7 of the section 34. Yeah, my lord. We'll keep the judgments on. 54 law we clear. My lord, has it, my lord?
Yes.
My lord, page 895, my lord has. I apologize, I should have indicated the page number.
Yes, 895.
895. My lord, I have not annexed this, my lord. This copy is from perhaps Indian Qanun. My lord, Kessel's engineering works. My lord, may look at the cost title versus neometallics. Same proceeding. My lord, paragraph 1, if my lord may note the date, 8 July 2014.
Yes.
Paragraph 1. This petition has been preferred under section 14, subsection 2, read with section 18 of the Arbitration and Conciliation Act 1996, the Act, to seek termination of mandate of the arbitral tribunal consisting of 3 learned arbitrators.
Then it was a different composition.
Different composition. If my lord pleases, I can show.
All 3 were different.
My lord, I can show, my lord, it's the first paragraph of the award, my lord, lays out the entire history. Subsequent to this, my lord, to satisfy my lord, I'll place that.
But all 3 were different, or the presiding.
My lord, at least, my lord, the presiding arbitration. My lord, I'll not, my lord, want to make an incorrect submission. I'll just, my lord, just like my first paragraph of the award. The third paragraph, my lord, may take on the next page. The proceedings have been progressing before the tribunal since 30th of March 2010. Unfortunately, the presiding arbitrator suffered a heart attack and proceedings could not be held for a substantial length of time. However, as things stand, 27 sittings have been held by the arbitral tribunal. And during this time, the parties have completed their pleadings and the respondent claimant is leading its evidence. The second witness of the respondent is under cross-examination. And at that stage, this petition was preferred by the petitioner in May 2013. And since then, proceedings have been held up as this court has repeatedly directed the parties to request the arbitral tribunal to adjourn its proceedings from time to time. Now, here, my paragraph 4 is important. The grievance of the petitioner is that the presiding arbitrator, having suffered a heart attack, has not been able to fully recover and is physically as well as mentally not in a position to preside over the arbitral tribunal. Same thing. In this respect, learned senior counsel for the petitioner has urged that firstly, the proceedings were adjourned for long durations. The proceedings had been fixed on such and such date. They had been adjourned to so and so. However, due to ill health of the presiding arbitrator, proceedings could not be held till such and such, i.e. for a period of 7 months. Subsequently, due to ill health of the presiding arbitrator, proceedings could not be held for nearly 10 months. That is between such and such and such and such. My lord may take paragraph 7. I will not trouble my lord with the previous paragraph. My lord may take page 897, if my lord pleases. The petitioner has sought to urge that on account of alleged non-participation of the presiding arbitrator, the other 2 arbitrators are not treating the petitioner fairly. The petitioner has sought to urge that it has not been granted adequate opportunity when compared to the opportunities availed of by the respondent in the matter of filing affidavits, documents, etc. by the tribunal. The petition, next paragraph, the petition has been opposed by the respondent.
No, if the first petition was in Delhi High Court, how could they come here now?
jurisdiction was. I'll show the agreement.
It was
Yes.
turned down on jurisdiction ground.
No, it was Delhi. Delhi. It was Delhi. They had filed it. I'll show the.
So then how can they come here now?
The agreement provides for it. I'll show the arbitration clause. There's no objection on that regard. We are not.
But section 42 comes in.
I'll show the agreement, may just note that I can see what is troubling, however, we have not raised this objection with respect to.
Your section 36 which goes also then.
Yes. No, I'll show the agreement. It is. I'll show the agreement. Kindly, allow me to place. Paragraph 9, the further submission of Mr. Gupta is that no such objection was raised from January 2012, recovered from his email till 2013, which shows that the objection raised is a mere afterthought and has no substance. Then, the next submission is that precedent proceedings are intended only to delay conclusion of the arbitral proceedings. Mr. Gupta has pointed out the first witness of the respondent was cross-examined in about 15 sittings such as. Now, the findings, if my lord may kindly take paragraph 12. Having heard learned senior counsel for the parties, I am of the view that there is no merit in this petition. Merely because the learned presiding arbitrator may have suffered a heart attack, it cannot be assumed he is either physically or mentally incapacitated from acting as an arbitrator. So also is not signing some of the minutes of the meeting does not lead to the conclusion that he was incapacitated. And that is why minutes were not signed. Pertinently, the petitioner did not question the arbitral tribunal or the presiding arbitrator as to why he was not signing minutes from time to time. The presiding arbitrator has not even been given an opportunity to explain his position as to why he had not signed some of the minutes. Merely because he may not have signed some minutes, it cannot be concluded that the omission on his part is on account of lack of physical or mental capacity. My lord, paragraph 16, my lord, his allegations with respect to not being treated fairly are also, my lord, disposed. Same modus operandi, cloaked, my lord, under a different section. And I further submit this. If they thought he was unfit, prior to him, my lord, prior to the tribunal having passed the award, why didn't he file another section 40? Clothed in, my lord, a different robe, same modus operandi, and same method of not, my lord, questioning the tribunal when they had an opportunity. 2 hearings I showed, my lord. Nothing. My lord, here, my lord, may I now take my lord to the documents they showed to, my lord, attempt to paint a picture that he was mentally incapacitated, whereas those documents do not show. May I show the first document shown? My lord, the first, my lord, was the discharge certificate. My lord, dated, my lord, 28th May 2020 at page 10. Lord, I'm led by Mr. Bagh.
Yes.
But I apologize for not, my lord.
No.
Being. May I first indicate the query which has fallen from your lordship, my lord, with regard to the jurisdiction.
Yes.
That AP1 of 2025, volume 5, your lordship will find at page 561 is the arbitration clause. Clause 17.2.
Which volume?
Page 561, volume 5.
Yes. No, I don't.
We are 17.2. Section 34, my lord, volume
Yes.
5.
APCOM.
APCOM. Page 561.
561.
561.
Yes.
At the bottom, my lord, 17.2. 17 is the arbitration clause. 17.2. The place shall be Delhi or Kolkata.
But section 42 sets in.
Yes, my lord. It does. It does. Now, my lord, if it does, then, my lord, the jurisdiction will be the first point. Because today, then, section 34 The
Yes.
challenge before your lordship,
As well as your section 36.
indeed, my lord, because it all covers, my lord, through that.
So let us
It's
see the-
only section 9, which is, my lord, outside the ambit of 42 for an urgent relief. Notwithstanding, so it's a non-obstant clause, my
That
lord.
yes, that court alone shall have jurisdiction over
Anything contained elsewhere in this part, and I'm very grateful because, my lord, this says it is something which had, my lord, we had missed this. I should be candid.
They had also missed.
We have missed this, and that is why when it has fallen now from your lordship, my lord,
The language is mandatory.
so, my lord, if it is Delhi or Kolkata, my lord, we have an option of
Delhi had-
choosing. But if it has been chosen before through a Section 11 proceeding,
Yes.
then, my lord, it cannot be recanted.
Section 42
Section
overrides
42
your-
overrides, my lord, all the other provisions, except perhaps Section 9, because, my lord, Section 9, if we move a petition, then, my lord, it can be through any court, which is, my lord, for urgent relief, and we can come back and, my lord,
Section 9 accepted. How
through
can you
judgments. I remember reading a few judgments where, my lord, there's a distinction, my lord, which has been carved out because of the urgency. See, my lord, that will not be also because of the assets. If the assets are in a particular place, my lord, and it is to be protected, then a Section 9 is filed there, but may not be the jurisdictional court.
What are the two here the after the
If
section?
I can, with the permission of the court, if I can just interfere, Malaj.
Yes, Mr. Shindra. Yes.
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 Yes. So, Malaj, may please see the heading of the arbitration, the heading of that 17.2. This
Yes.
is the place of arbitration, Malaj. This is not the place of jurisdiction.
Right.
Yes,
Right,
the jurisdiction clause.
So the place of arbitration can be Delhi or Kolkata.
Yes.
In
but
other
it's
words,
not-
the seat. No, Malaj. In other words, the seat of arbitration. The
Yes.
seat of arbitration was always Kolkata. All proceedings happened in Kolkata. Then that judgment kicks in, Malaj, of Justice Nariman, which says that the seat will override everything else.
Correct.
If the seat is here.
Seat overrides everything else, Mr. Chindra. But did Justice Nariman consider also section 42?
No.
Malaj, I can look back to
No,
that
no,
judgment,
no.
and that's why we came.
Seat definitely overrides everything else.
Yes, Malaj.
Doubt on that. But
Yes.
section 42 overrides everything else. And there's a
No,
non-obstante clause.
No, so if the seat has always been so, Malaj, actually that judgment came after this 2014
No, in fact,
place.
in fact, Mr. Shindra, 42 is the only section 42. In our discussions also, we deliberate on this because section 42 is the only clause
Malaj,
which is of its own kind. I mean,
Malaj.
it overrides everything.
My lord,
Even if you file it outside jurisdiction, you can agree to a even beyond the seat if you agree to a different if you file a petition anywhere else.
Yes.
So you can argue probably that notwithstanding anything, this court should be a competent court. I mean, being the seat.
Therefore, post that judgment of Justice Nariman, that court was never a competent court because the seat of jurisdiction was always this, Malaj.
But Delhi or Kolkata is a place.
No, so that's right. No, Malaj. So the place could have been Delhi or Kolkata. As a matter of fact, it was always chosen to be Kolkata. It was never chosen to be Delhi.
You moved Delhi under section 14.
No, Malaj. No. So in section 14, we moved in Delhi, Malaj. But as a matter of, so that judgment of Justice Nariman came only later, Malaj. 2014 is this judgment that is being shown to this honorable court.
I'm
The
carrying
judgment of
that
Justice Nariman came only later, which clarified that, look, it's the seat of the arbitration which will govern the situs of the challenge to the jurisdiction. Therefore, we moved to this court because the seat of the arbitration overrides all, and in the light of that judgment, section 14, perhaps the one that was moved, was without jurisdiction.
Seat, Mr. Chindra, is both Delhi or Kolkata. Both.
No, Manoj. No, so the arbitration clause says so, but as a matter of choice, it was always Kolkata, Manoj. So in other words, if I can say so, it's just like saying that the two courts have jurisdiction, you can go either here and there. As a matter of choice, the seat was always determined to be Kolkata. That's why we came here, Manoj. I mean, allow me to, Manoj, have that judgment and place it back to this honorable court. But that is the point, Manoj, why we moved Kolkata.
That's execution. That's different. Yeah, 36. Correct. Lord, may I
36 is different.
this?
Yes.
Lord, BGS, SGS Suma, the judgment, Lord.
Yes.
Yes.
This is 2024 SCC.
Yes.
234.
Hmm.
My lord, because it actually opens up an avenue, my lord. We have to argue this first. This is the jurisdictional issue. My lord, BGS Soma versus NHPC Limited.
Was it 2024 3
2020 volume 4.
or 2020 volume?
2020 volume 4
234.
SCC 234.
Yes.
My lord, I'll tell your lordship, my lord, the paragraphs, it's the juridical seat of arbitration proceeding is discussed from paragraph 22. And my lord, paragraph 32 of this judgment is, my lord, on the point of the concept of juridical seat being developed. My lord, Balco is considered, and this judgment, my lord, is thereafter also, my lord, with the term, the subject matter of the arbitration, this is related, my lord, with 21E, the court and the seat and venue. And thereafter, the conclusion is, my lord, drawn for tests for determining the seat. It's paragraph 59. That is where, my lord, section 42 is considered. That's paragraph 59 of the judgment. May I read that portion, my lord, of the judgment?
Give me half a second. I'll just find out the judge.
Yes, not in us, of course. Correct. Yeah. No, we should. Can we?
No, judge.
May I airdrop this, my lord, because it will come as a
Because
mark
it's Samsung. I have Samsung.
Extra iPad will just hand over a copy.
I rather prefer Samsung than Apple. It's not an ad, but
You have the entire file? Judgment with the series of judgments. Oh, okay. My lord, I have all the judgments in one place. May I hand it over? It's, my lord, bookmarked one after the other because I was arguing this point in another matter, my lord. That is why I have it handy.
59. First, let us just do this.
Gotcha.
Yes. 59.
Paragraph 59.
Yes.
After discussing in this mobile in 58,
Yes.
59, my lord, equally incorrect finding in Antrix that section 42 of the Act would be rendered ineffective and useless. Section 42 is meant to avoid conflicts in jurisdiction of courts by placing the supervisory jurisdiction over all arbitration proceeding in connection with the arbitration clause, arbitration in one court exclusively. This is why section begins with a non-obstant clause and then goes on to state where with respect to an arbitration agreement, any application under this part has been made in court. It is obvious that the application made under this part to a court must be a court which has jurisdiction to decide such application. I pause here for a moment. My lord, here in this matter, Delhi High Court has jurisdiction because it's a or clause which is given.
Yes, that is a difficulty. If it was
Sundaram
Calcutta,
Finance actually, my lord, saves us from 36. Sundaram
Yeah.
Finance says 36 goes outside the ambit of 42. You can file it. So my lord, my 36 gets preserved, but I have to argue that. Here, my lord, it is obvious that the application made under this part to a court must be a court which has jurisdiction to decide such application. The subsequent holdings of the court that where a seat is designated in an agreement, the courts of the seat alone have jurisdiction would require that all applications under part 1 be made only in the court where the seat is located. Since here, my lord, it's two options.
yes,
That is where, my lord.
please go on
And that the court alone has jurisdiction, then has jurisdiction over the arbitral proceeding and all subsequent applications arising out of arbitral agreement. So read, section 42 is not rendered ineffective or useless. Also, where it is found that facts of the particular case.
This view has been taken by our High Court also, Mr. Chinda, for you
Well,
also.
well.
This High Court has also taken this view that if it has to be a court to mean a court, it has to be a court of competent jurisdiction.
Absolutely.
We can go by that. If it's
Yes.
an absolutely incompetent court, there you file the first application. We are not looking at section 42.
Also, Malaj, the aspect of seat is also an aspect that it has to be a unified seat. You can't have more than one seats.
But here we
can
can
be more than one.
Yes, definitely.
So
Definitely.
seat,
seat
the
has
whole concept of the evolution of the seat was to give
Yes,
a definitiveness.
right.
Was to give a definitiveness for the place of the arbitration. So irrespective of the fact that the Arbitration Act, arbitration clause may say that the place shall be Delhi or Kolkata,
Huh.
as a matter of choice, it's just like saying, Malaj, that it's just like saying that you have an option to go to two courts. Parties can decide to go to which
Yes,
court.
in civil matters, the usual matter.
In civil
So
matters.
here you
Modi
say that because all of the sittings of the arbitral
was in
tribunal were
Calcutta.
all right.
The seat was in Calcutta, Manoj. Nowhere else. Venue may sometimes have been Durgapur and some other places, but as a matter of fact, parties chose to be in Kolkata. All sittings happened in Kolkata. Out of 89 meetings, arbitration happened in Kolkata. One of the parties is a resident of Kolkata. So seat as a matter of choice was kept here, Malad. So you can never have two seats per se. You can't say
Otherwise, we'll have to construe that the seat is all over India because Delhi and Kolkata.
it's
you have
everywhere.
to-
Then every court will have jurisdiction. Then
Every
you have
court
to
will
go
have-
into
yes.
42 and so on and so forth.
The purpose of seat will be frustrated.
The defeated, Manoj. And the whole aspect of a seat was always a unified seat. You can never have two seats per se. And it's because of the choice of the parties that, and if my lord see that judgment, the
Yes.
evolution of the seat since para 32.
Hmm.
That's where Justice Nariman also says that, look, the whole concept and the evolution of the seat was for this purpose.
We'll proceed on that premise for the time being.
But may
Yes,
I?
my lords, I'll
Very-
have I'll put in more judgments if required.
If required, yes.
Yes.
Perhaps it will be required. I'll place that why, my lord. But kindly see the next part, because I was saying section 9, my lord, as a exception. The next few lines of that paragraph 59. And this has been clarified in Arif Azim, that's the next judgment I'll refer to, my lord, where it has been now held that seat and venue is actually the same concept. Seat is equal to venue.
No,
And that's, my lord, in 2024. I'll quickly indicate this part. So read, section 42 is not rendered ineffective or useless. Also, where it is found that on the facts of a particular case, that either no seat is designated by the agreement, the so-called seat is only a convenient venue. Then there must be several courts where a part of cause of action arises that may have jurisdiction. Again, an application under section 9 of the Act, over the page, my lord, may be preferred before a court in which part cause of action arises in a case where the parties have not agreed on the seat of arbitration, and before such seat may have been determined on the
May have
facts of
been.
a particular case
Yes.
by the arbitral tribunal
Yes.
under section 22 of the Arbitration Act. That's for section 9. In both these situations, earliest application having been made in a court in which part cause of action arises would then be the exclusive court under section 42. This is where, my lord, my case lies then. Then Delhi is the exclusive court, my lord, because part 1
So
section.
there is no part of cause of action which arises in Delhi, my lords, even then.
But that's for section 9. This is on a much lesser footing, my lord, because section 9 is on a much higher
No,
footing.
but Mr. Bagh, Mr. Chindra has a point when he says that by conduct, because Delhi and Kolkata cannot be together the seat.
Very great.
These are two places. You cannot juxtapose yourself to two places at the same.
Indeed.
But the only thing which can be constituted is by your conduct.
My lord.
So it's ultimately party autonomy. It's all about party autonomy in entire arbitration.
Indeed.
So if both of you have all the sittings of the arbitral tribunal have taken place in Kolkata and everything
Before
in
it
Kolkata.
started, my lord, the choice was made by the respondent where they chose to file a section 14 in Delhi.
Okay.
So
Once that has happened,
post,
my argument
post
is
the first application, you cannot
I'm very
change
grateful.
the
I'm very,
seat.
very grateful. That's section 42. I'm sorry, my lord, we should have noticed this. This is something which we have missed.
This
is-
this
So
will take
Malaj,
another vacation for me to decide.
No,
Then.
no. If
I
I
was
can,
hoping to decide it within the winter vacation.
So,
I
Malaj,
understand. This is a very interesting point. I really want
So,
to address your lordship on this point.
Yes, continue
Malaj,
arguments so that I don't fall within that 3-month that thing. So please continue arguments on jurisdiction till the next puja vacation.
No. So there,
Well,
Malaj,
we'll come back to this, Mr. Chandra.
Yes.
Better to come back to this.
No difficulty.
Let them.
May I
I'm
make
disturbing
you
the flow.
submit this?
No difficulty.
May I address your lordship on
No,
this point?
First, Mr. Bagh, since Mr. Chandra has argued at length,
Indeed, yes.
and you have also argued, you have started arguments. One or two most important points have been argued already. So let us complete this.
Only difficulty I will be facing then, my lord. Also, perhaps, my lord, for the honorable court, if this point of maintainability, my lord, is first decided, then my lord, nothing remains in the matter. I do not know whether, my lord, we should then proceed with the matter on any other front, because, my lord, I will only show two judgments, my lord.
That's
After this, I'll show, my lord, 2024. That's, my lord. I'm also putting my learned friend on notice because these are the points which, my lord, will crop up because of section 42.
He's not on your side. Oh, learned friend means Mr. Chandra. You're showing the screen. I was stunned for a moment. Yeah.
Lord Arif Azim is what I'll be relying on. That's 2024.
So, Mr. Chandra, do you agree to hear the jurisdiction point first and get it over with, and then proceed with the main hearing.
Malaj, then, Malaj, we have argued substantially. They have also
That is what I was
submitted
thinking.
also substantially.
Sabag, one other thing, no, but
And
we have,
also no aspect of jurisdiction has been taken
because
in the
jurisdiction point was, it never was raised by
Raised.
any of the parties.
Yes.
We have,
So
yes,
to be fair to both of you, I mean, it's
maybe
the
come back. One day I'll argue this. I'll also enter into the merits.
no, Mr. Bag, what you complete your arguments, because I don't think you
I will, Milord,
require
I
more
will.
than a day on the main arguments.
It would not be, Milord. That is why
Let
next
us
day,
complete the main arguments, because it's following the principle of Order 14, basically, Order 14 Rule 2.
first issue, Milord, the
The first
preliminary
issue, but despite the matter, the court being able to decide the matter on a preliminary issue, court has to hear the other issues.
May I humbly submit this?
Because it's a mixed question. It's a mixed question.
It is. But Milord, today, all the admitted facts, if I take, it's only one admitted fact, two admitted facts. Milord, Section 14 was filed by them, Delhi High Court. Milord, all the sittings happened in Calcutta, not objected to. Only two facts, Milord.
The only question which remains is whether after choosing the first court, after making the first application,
Can you recant and reconcile even with the agreement between the parties? It can't be done. That's perhaps the Milord premise
the
of
peculiar
42.
situation where there may
Malaj,
be
if
a
I can-
conflict between seat and yes.
Yes. So if I can just Malaj, clarify, the law declared in 2020, being the law, Malaj, is applicable at any point of
So
time.
then Mr. Shindra, we for the time being, we are stopping the main argument for the time being, and let us hear the jurisdiction issue today itself, because Mr. Bag is ready with the judgments.
Malaj, I may not be, since it was not.
No difficulty. We'll give you some time. We'll give you some time.
I was not. Isn't it better, Malaj, to hear than the entire matter, and as my lord said, to determine this and that both ways, even if this honorable court says eventually that it is not
considered by your lordship, Milord. Next Friday, if we come, Milord, we'll not argue on this point for more than half an hour. Not even half an hour, Milord. 15, 20 minutes.
Mr. Bag, what I'm telling you is, how long do you expect to take on the main matter?
2 hours.
No. 2 hours regarding making of the word at least.
We have till 1 in the first half, and from 2 to 3 today in the second half, because 3 there's a special bench. So if you can complete the main arguments today, and we can take up the jurisdiction point on the next.
No, wait. I think better will be to just come back and argue on one day. Milord, may I submit this subject to your lordship's kind consideration? Next week, Milord, Friday, if we come back and Milord, we utilize the entire time and complete our submissions, both on the point of maintainability and the.
Won't be possible because
merits.
Mr. Shindra will also be arguing, so both of you won't be able to finish on that day.
Milord, the first half will conclude. I don't think we'll take more than we'll file notes, Milord.
No,
Section
then on
34
the main arguments, you can complete today the main arguments.
Milord,
on the main issues.
the only reason
We have already heard Mr.
back,
Shinde at
perhaps,
length.
Lordship.
He has opened up, and you can also complete your main arguments, and we can hear the jurisdiction point on the next day, so that he also comes prepared. We'll finish jurisdiction on that day.
Because I'm very, Milord, perhaps now all of a sudden I get convinced that, section 42 is perhaps our answer to, Milord, the jurisdictional issue. It's not really an answer.
If
but
you
Milord,
come
whether
this side,
this
Mr.
honorable
Bag,
court-
we hope you will. I mean, every moment you get convinced, the reverse conviction comes up the next moment. So this being convinced is nothing. I mean, it's a chimera. It's an illusion.
As your lordship, Milord,
Your conviction now may change the next
indeed,
moment.
Milord, only this because, Milord, that one clause and the jurisdiction clause and the fact that they have exercised their, Milord, right at the first instance under section
How many
14.
points do you have in the main? You have several. The
7
main
points,
matter
Milord.
is almost you have argued half your points.
7 points, Milord, if I have.
Making of the award.
You argued 4, probably 3.
All have finished arguing. Almost 1 point left. Now I have to argue.
Fraud, that period, that
period
warranty
of-
period,
Milord.
and these bills, the
And
documents.
31, 2, Milord, the signature part, and Milord,
Yes.
the documents, whether, Milord, the interpretation is correct or not. So only on these 4, 5 aspects. That is why, Milord, I'm submitting, I think, one half will be concluding. Will not require more than that.
For what? On what? The main.
On, Milord, the main merits. That
So
is the
do
reason.
that today. Do that today. I will come back on. I'll not reserve judgment. Do that today.
My learned juniors are, Milord,
Do
insisting
that
that,
today. No,
that they have taken 2, 3 days. If we can get 1 day and we will conclude on
no,
that.
it's not dependent. It's not a.
No, indeed, I know that. Milord.
And I've indicated to Mr. Chinda also, whoever is shorter has a better chance of winning.
Milord, kindly permit
He
us.
has notice of that. So you complete whatever you are arguing, complete that. Because today we don't want to lose a day. After that, if jurisdiction point is argued, then I'll come back after the vacation and decide on jurisdiction. If I hold there is no jurisdiction, I don't have jurisdiction, then it's all right. But if I hold otherwise, then
No, I'll not make piecemeal submissions. My lord. I'll conclude with
therefore to
the,
conclude this submission. In any event, if I hear you on jurisdiction as well as the main matter, he has argued on the main matter.
my lord.
You have 1/4 argued on the main matter. So let us conclude the main
I
matter.
really do not. Lord, what have you argued till now? Kindly, may I have 1 minute, my lord?
I shall take that break and take a call on this. I want to look at it.
Hmm. Hmm.
Contains fraud in 31(2). Was finished fraud in
He has argued it fully on merits. You have started arguments on merits.
We will, my lord, we'll
So
carry
we
on.
can hear out the argument on merits today and come back on the next day on the jurisdiction part.
But
Take
may
a call.
May I only make one prayer, my lord? There's a fixed matter. My learned junior will continue till, my lord, I'm stuck there. I'll come back and I'll continue.
Yes,
with
it's no difficulty. You can interchangeably, but
Very
don't start all over again.
No, I won't.
Just like
That's why I want to know, my lord, what has been submitted.
yes. So I'll come back in 5 minutes. Take a decision on that at least, so that you can have a talk with Chandra using the court system also.
But unfortunately, I don't believe my learned senior could confer with my learned
Acha.
senior friend from the other side. May I submit this, my lord, if my lord,
Yes, yes.
lord, as I had initially indicated, my arguments and my responses are under two tranches. One is with respect to the making of the award.
No, should we hear the merits
With
then?
respect to the making of the award. When my lord says merits, my lord, I'd submit, subject to my lord's thoughts, my lord.
No, by merits, I also mean the everything which has been argued by Mr. Chin.
The contents, my lord, such as, my
No,
lord,
merits as opposed to jurisdiction of this court to hear them.
my lord, I submit, my lord, the merits as in the contents of the award, being whether it is in excess of, my lord, the agreement, my lord, those can be heard, those points ought to be heard along with, my lord, jurisdiction. My lord, agreement will have to be placed.
No, we
etc.
cannot truncate it. If the section 34 is not maintainable here, we cannot hear any of the points,
Very well.
either fraud or anything.
My lord,
So then we'll hear the jurisdiction
just
point
make
first.
one request, my lord.
Yes.
My lord, I was on the last factual aspect of the argument I was making. If my lord is so pleased, my lord, may that be completed so that I'll not have to start from the beginning.
No, that was the intention. That's why I
Just the
gave you an
last
option.
factual aspect, my lord, on this point, my lord, then my lord's time will be saved, my lord, and I'll be able to close that argument. Subject to my lord, then I will not place the judgments I wish to place. May I at least, with respect to fraud, my lord, my learned senior may complete that argument.
No. If you complete that, I mean, it's no use completing that. Continue, please.
Started, my lord, just last fact.
Started, I'll forget on the next day. So no difficult on that. But Mr. Chadi, it's no use if you decide to. Are you prepared to argue on the jurisdiction point today?
We don't have all the judgments. That's the whole difficulty. I was just checking, my lord, because I need to also be sure, my lord, of what I'm arguing. So, my lord,
and you also have
between
to
that-
argue on section 36 because you're trying to draw a distinction between 36 and 34.
yes, my lord.
Because the
36
twofold,
Sundaram
whether
Finance says
whether
that, my
34 is maintainable and whether 36 is also maintainable because you want to draw a
we
distinction.
cross check, my lord. 36 is maintainable. We
We
cross check
On both points will be
on
hearing.
both points. My lord. Otherwise, it will be piecemeal. So, my lord, our contention would be 34 will not be maintainable, but 36 will be maintainable.
Mr. Chinda, then I can record in my judgment order today that after I heard you completely and their arguments commenced, this question fell from the court.
Yes.
And we decided to hear the jurisdiction point first before proceeding further because I've already heard you.
Yes,
Let us hear it on jurisdiction. Let me decide it within a week thereafter, and then the next week, I mean, and we'll come back with the conclude the main arguments if I hold it in favor of jurisdiction. If I hold there is no jurisdiction, then I mean it's a wastage of time.
Indeed, my lord. That's
no, Malaj, that's right. That's correct.
But Delhi judgment was never it never came up before me. That's why if
That's right.
it,
Malaj,
had
it
come
was
up,
not. It was not also raised in their defense, right?
not raised in the defense and not relevant for your arguments also. So you did not place obviously.
Malaj.
also, my lord, only because it fell from your lordship while I sat, my lord, I just cross-checked the arbitration clause, it struck. Otherwise, my lord, it would not have occurred to us also. My lord.
Right. So we'll hear then on jurisdiction point. Please come prepared. Come prepared, Mr. Chindra, on two grounds because when the question fell from the court that section 34 and 36 are not maintainable, Mr. Bagh seeks to draw a distinction between 36 and 34. He's saying there are judgments to say that 36 may be maintainable despite 42, but 34 is not maintainable.
Fair enough.
So you also come prepared on that, and if you can, both of you, please exchange your judgments if you can. Mr. Bagh and Mr. Chandra, please just take your time. Before you come back the next day, just exchange your judgment citations so that you can come prepared on everything.
We'll do that, definitely.
That will be better. So I'll record in my order and keep it next Friday.
It'll be, Malaj will keep it on the 19th?
Yes, 19th, Mr. Chandra. That's because I take these matters up on singly, I sit singly on Friday.
No difficulty, man.
The petitioner in the application under section 34 of the Arbitration and Conciliation Act 1996 has already been heard at length. Full stop, next para. However, after commencement of the arguments of the respondent in the said application, during arguments, learned counsel appearing for the claimant/respondent seeks to place reliance on an order passed by the High Court at Delhi. It was the High Court.
High Court.
Yes,
Delhi High
The
Court.
High Court at Delhi. It was under section 14 and
read with section 18, man.
in connection with an application under section 14 read with section 28. 25 of the Arbitration and Conciliation Act 1996. Full stop. As a consequence, comma, a question fell from the court as to whether the bar under Section 42 of the 1996 Act would be attracted, comma, in view of the jurisdiction of the Delhi High Court having been 14 read with Section 18. In view of the jurisdiction of the Delhi High Court having been invoked earlier, and in view of the relevant arbitration clause in the agreement between the parties designating both Delhi and Kolkata as the place within double inverted of arbitration, comma, whether the applications under Section 34 as well as under 36, Section 36 of the 1996 Act would be maintainable before this court. Full stop. Since the jurisdictional issue hits at the very root of the maintainability, comma, upon consultation with learned counsel, comma, this court decides to hear the jurisdiction point first and thereafter proceed to decide on the merits of the matter. Full stop. Accordingly, to enable learned counsel to prepare themselves on the jurisdiction issue, comma, let the matter stand adjourned till December 19, 2025, when it will next be listed under the same heading. For being taken up at 10:30 a.m. 10:30 would suit you, Miss? Well, 10:30 would be easier because I'll take this up first and then go on to the next one. 10:30. Thank you.
I'm
very much.
obliged.
May I apologize once again? I'm deeply embarrassed
For
for the
what?
tardiness. I should not. I am grateful.
Forget that. He's apologizing, Mr. Chinra, profusely because he was in a car when he no.
Really do not
Do they
come
matter
late.
in my court? Mr. Chada, are you seriously? I mean, you need
Right.
to apologize.
Really do not come late.
Till now, you don't know. I mean,
Grateful. Man.
these are.
I'm very deeply obliged.
Thank you very much. Thank you.
Obliged, man.
তাহলে appellate side নিতে হবে।
May I mention one matter?
Appellate side matter?
Fine.
Yes, sure.
But,
One minute. Let it be formally.
Fine.
Yes. Let the files come. Bolo, any mentioning? Yes.
May I mention one application for recalling one?
Single bench.
Fine.
Absolutely, please. এটা দিয়ে দেবেন লিস্টে।
Item number 1.
It transpires from the orders passed in the matter previously that the parties have remained absent on repeated occasions at the time of call. Full stop. Accordingly, SA 507 of 1965 is dismissed for default without any order as to cost. Interim order, if any, stands vacated.
Item number 2.
Same. এটা একই লটে ছিল একই।
Item number 3.
None appears at the time of call. Full stop. As a last chance to the appellant to argue the matter, comma, let the matter stand adjourned till December 19, 2025.
Number 4.
The parties have remained consistently absent at the time of call on previous occasions as well. Full stop. Even today, comma, at the time of call, none appears for either of the parties. Full stop. Accordingly, SA 851 of 1965 is dismissed for default without any order as to cost. Interim order, if any, stands vacated.
Item number 5.
Take order. পাস ওভার থাক অ্যান্টিসিপেট করবে না ফাইল তোলার আগে দেখে নেবেন এসছে কি উকিল পাস ওভার করতে করতে যাবো
Item number 6.
পাস ওভার
Item number 7.
পাস ওভার
Item number 8.
পাস ওভার
Item number 9.
Item number 9, I am appearing for the petitioner, my lord. My lord,
appearing for the first time.
no, my lord. This was adjourned sine die till the appeal was to be heard.
Oh.
But subsequently, when we mentioned the appeal was dismissed for default, as far as the union's appeal was concerned, both the appeals were dismissed for default. Now, my lord,
You also had an appeal.
No,
You
no.
go for the
one is for one union filed one appeal, state filed another appeal, my lord. Yes, as far as the union's appeal is concerned, the appeal has been restored, my lord. I will be fair with you, my lord. As far as the state is concerned, my lord, they have only restoration has been filed. It has not been.
But one of the appeals is restored, so it had been adjourned sine die.
Yes, my lord. My lord's last order. Yes,
Then
but
let it go out of the list with liberty to mention whenever the appeals are.
my lord, here is the appeal, my appeal court's order, my lord. As soon as it was dismissed, my lord, we mentioned so that.
Oh.
Yes.
Learned counsel for the petitioner points out that the matter was the contempt application was adjourned sine die on November 8, 2024 in view of the pendency of two appeals, comma, one at the behest of the Union of India and the other at the behest of the state, comma, against the parent order. Full stop. Subsequently, upon the appeals being dismissed for default, comma, the matter was mentioned for inclusion in the list. Full stop. However, comma, subsequently, comma, the state's
Union's appeal has been restored.
The appeal preferred by the Union of India has been restored. Full stop. Hence, comma, in view of the earlier order, comma, let the matter go out of the list with liberty to the parties to mention for inclusion in the list as and when the appeals are decided.
My lord is sending it out of the list.
Finally, yes. What is the use of remaining in the list?
Well,
we only glorify the list.
Well, they won't.
You mention immediately, take up.
Well,
you don't have any other bench for contempt.
Well,
there is no option for me but to take.
Only one of them has been restored, not others.
Even if one remains, then it's the effect is the same. If that is allowed, then your order my order goes.
Well,
next.
Number 10 to 20.
Lordship, item number 10 to 20 in this matter, Ms. Pona Rao Choudhury appearing with the alleged contempt number 1 for the Punjab National Bank. If she has any court number 551, make it short pass over, Lordship.
No, the others are there.
I'm for the applicant number 1, Lord. I appear for national insurance. An impression has been sought to be created upon your lordship that it is only the fault of the insurance company that the amounts could not be disbursed. I mean, the premium amounts could not be lodged at proper time. And therefore, my lord, this crop insurance, which is assured under the scheme of the West Bengal government, has not been carried to its logical conclusion. But I am afraid to say, and I'm constrained to make this submission, that, my lord, the bank, the PNB being a nationalized bank, has made statements contrary to records. And my lord, it is the absolutely the fault of bank that this is not being processed. And I will demonstrate it right now. Well, kindly take, my lord, may I just hand up the copy of the writ petition? Well, that an order was relied on order passed by a coordinate bench was relied on the last occasion, which forms part of their opposition. Kindly first take the order. Kindly take the affidavit in opposition, reply, right? Reply, opposition filed by
Opposition or reply?
opposition filed by the bank to my recalling application. Page 14. May I just take your lordship through the order? This was affirmed on my lord, April 24. Well,
Affidavit filed by the IDBI Bank.
no, I am on PNB, Punjab National Bank.
Punjab Bank, in which matter?
My lord, in my lord Lal Mohammed, I believe, my lord. Kindly give.
No, Lal
No,
Mohammed ID.
no, my lord. My lord, this is
Mohammed is-
Shubham Mahapatra. I'm sorry, Shubham. তাই তো? Shubham Mahapatra.
সম্ভবত কোনটা দেখুন?
সিপ্যানটা হচ্ছে আপনার 1996 of 2024. এটাই তো রিলাই করেছিল আগের দিন। The same identical oppositions have been filed. Well, I am just taking your lordship to one of the opposition
ওই ফাইলটা দাও।
filed by the bank.
আমাদের ফিজিক্যাল কপি দেন না ফাইল খুলতে টাইম লাগবে কন্ট্যাক্ট এদিকে আমরা
An order date 1st of August.
Yes, my lord.
Yes.
Yes, ma'am.
Got
May I just read it out? This is an writ petition filed by PNB. The prayers made in the writ petition cannot be allowed by this court. This is how, my lord, the order starts. The petitioner seeks an opportunity to upload the data. My lord, kindly take the date. This is 1st of August 2024. Upload the data with regard to transmission of the premiums deducted from the accounts of the farmers to the National Insurance Company Limited. The impugned order records, well, this is the order passed by the secretary. The impugned order records that bank had deducted premium and also transmitted the same to the insurance company, but the insurance company had not disbursed the crop compensation and subsidies, etc., payable to farmers on the ground that the data from the bank was not uploaded in due time. The Principal Secretary, Department of Agriculture, Government of West Bengal directed NICL and bank authorities to settle the matter of refund of shares of premium paid by the petitioners with interest at the rate applicable within 1 month from the date of receipt of this order. The bank has challenged such order or direction on the following grounds. The bank had deducted the premium from the accounts of the farmers and paid the same to insurance company, but the insurance company did not acknowledge such payment. For technical glitch, the data could not be uploaded. But this is the most important part. Such failure to upload the data at the correct time should not be treated as a failure on the part of the bank to do the needful. The advice to the bank to settle the matter with the petitioners as per the banking norms and extend suitable compensation was saddling the bank with a liability, although such liability would be of NICL. No, it's crop insurance basically. My lord, if there is a compensation is to be paid, it is to be paid by through the bank. Only, my lord, the compensation or it is insured by the insurance company. As NICL is not before the court. Interestingly, my lord, when the bank files a writ petition, the bank does not implead NICL as a party respondent. As NICL is not before the court, mandamus cannot be issued in this regard. However, the bank is directed to approach the NICL with the copy of the order impugned, as also with the server copy of this order. Both the insurance company and bank are directed to chalk out a mechanism by which the data can be made available to the insurance company by the bank with regard to deduction of premium, and the insurance company, upon receipt of such data, shall take steps as directed in the order impugned in the writ petition. The bank will approach the insurance company within 2 weeks from the date of communication of this order, and the NICL shall chalk out the mechanism with the bank within 2 weeks thereafter and act in terms of direction of the Principal Secretary, Department of Agriculture. So, the order is not interfered with. Payment shall be made to the farmers as per the said order within 2 weeks from NICL, receiving the data to be supplied to the bank by the bank. The rights of the farmers for refund have already been upheld by the Principal Secretary, Government of West Bengal, Department of Agriculture. The scheme also includes a crucial role by the state government. Secondly, NICL cannot ignore the order passed by the Principal Secretary, the Government of West Bengal, Department of Agriculture by remaining quiet.
NICL was only in charge of uploading.
No, my lord, what has the charge of uploading was with the bank. The bank is to, my lord, the premium, my lord, there are two contributors to the premium. One, the farmer, another, the state government. Farmer share is about less than 5%.
4.85.
4.85%, and the state share is about
10%.
10%. So it is about 14%, 15%. So, my lord, when the farmer deposits the premium with the bank, it is the duty of the bank first to transmit the data or upload the data in the portal maintained by the Government of West Bengal. My lord, suppose, my lord, I am an insurance company. From the bank, my lord, the payments are being transmitted to my account. My lord, unless and until the segregation is made or identification is made by the bank that this particular payment is relatable to that particular insurance policy, my lord, bank, the insurance company is not in a position to identify, my lord, whether the payment is a earmarked payment or not. What they did, my lord, they continuously, my lord, submitted before the before the coordinate bench as well as before your lordship that they could not upload the data due to technical glitch. This is the only branch of PNB, well, I am submitting this on instruction, which did not upload the data. Mala, the procedure which is laid down in the scheme is that suppose there is a glitch, Mala, there is a system administrator. Mala, the system administrator admittedly was never approached by the bank. They say on oath in the writ petition filed before the coordinate bench that they had intimated this to the insurance company. It was never intimated. This was never done. All they are required to do is now to make good the loss suffered by the farmers. They cannot saddle the insurance company with this liability. I'll tell you, lordship, may I just take your lordship?
Bank's liability was restricted to the farmer's share.
No, my lord, banks, my lord, it's a crop insurance. Suppose, my lord,
that 4% was to be
4% is, my lord, farmers share to
farmers
share towards premium.
It was deducted. The bank stand is that the bank had deducted the premium from the accounts of the farmers.
Right.
And they say they have paid to the insurance company, but you had not acknowledged.
Mala, it is not possible for me.
Their liability is restricted to that.
Mala, no, Mala, it is the insurance, but the policy.
You say that the entire policy could not be honored because of that.
Visualize, bank extends loan to the farmers. It is the loan which is insured. It is not limited to the, my lord, it is not limited to, my lord, any general insurance obtained by the farmers for regarding loss of, my lord, there may be loss of crops due to, there may be loss of, my lord, during one particular season, they may suffer loss due to some unforeseen circumstances. My lord, the bank, it is the loan which is getting insured.
So farmers get the loan for the crop?
Yes, from the bank. So, my lord, what they are trying to do, my lord, they are trying to saddle the liability with the insurance company, and this particular branch, I am making the submission on instruction. This particular branch has failed to upload the data. My lord, this particular branch has made an incorrect statement on oath before the coordinate bench that they had intimated the insurance company that they had do something about it. This was never done. If they produce
your submission is that they have to make good the, I mean, they have to waive the loan.
They have to waive the loan, or, my lord, some kind of arrangement is there, but it is the loan which is insured. It is the loan which is insured. It's all about the loan. Naturally, my lord, when my lord, this data was not uploaded, the state was also not in a position to pay its share of premium. One share of premium has to.
Why state share is irrespective of farmers?
Because, my lord, the first payment has to be made by the farmer, 4% or 5%. The balance 11% is to be made by the state.
But there is no first or second. The
Unless and until the data is uploaded,
so the shares are delineated. Even if the farmers, suppose the farmers have not yet paid. It's
Yes.
the state responsibility
The
independently
first,
to
how
pay
the system is triggered. System is triggered in this manner. Deductions are made by the bank. It is transmitted to the respective insurance company. Forget about NICL right now. When it is transmitted to an NICL account or the insurance company account, they are supposed to upload the data in the portal maintained by the government of West Bengal. When this data is made available in the portal of government of West Bengal, the government of West Bengal obviously would make its contribution. That look, this is the 5% they have paid, I have to pay also. What happened here, my lord, for 2 months, but there was a 3-month window. There is no explanation as to how long this technical glitch continued, why this branch was facing some kind of difficulty.
For 2-3 months, it was not uploaded.
No, it was never uploaded. During this entire window, it was not uploaded.
So after this order, what happened, sir?
My lord, after this order, my lord, what happened, my lord? কি হয়েছে এবারে? না এরপরে কি হলো?
But there was a direction by Justice Sarkar.
There is a direction by Justice Sarkar, but my lord, interestingly enough, my lord, I was not a party. My lord, the Justice Sarkar.
You are representing the insurance company.
But I was not a party in that petition.
Oh, that was regarding the uploading.
My learned senior was not there. My lord, the insurance company was party. The name was given as AICL, All India Agricultural Insurance Company. My lord, the name changed to NICL. The name was not corrected, but the address was same. Since the name was not there, that is why her lordship, my lord.
NICL is the insurance company.
National Insurance Company. There is no.
That's in it.
My lord, there is no AICL insurance company. I've never heard of any AICL insurance company. These are GICs, my lord. NICL, National Insurance, New India Insurance, Oriental Insurance are all the.
My lord, I can produce the copy of the writ petition.
I have the copy of the writ petition. Kindly take, my lord, what is the reading? Kindly take the writ petition.
The parties.
Parties is there.
Agriculture Insurance Company. My lord,
Agriculture Insurance Company is no company. I'm sorry to say. I'm sorry to say to make this statement. This cannot be the stand of a nationalized bank.
Sir, may I say? I'm submitting before the court, sir.
Please, let me conclude, then kindly make your submissions. Right?
This was submitted before the court that NICL was not represented. My lord. That is why I interrupted that AICL, my lord, we have made a party based upon the earlier writ petitions. In the earlier writ petition, my lord, in regard to which the contempt is like, my lord, in every writ petition, my lord, AICL was made a party.
They appeared also.
They did not appear. Despite of service, my lord, they did not appear. Getting the address, my lord, we have given the same address as AICL. Then, my lord, it was found NICL, and that's why NICL was not represented.
My learned friend has concluded. Let me make submissions.
That juncture when this writ petition was filed, NICL had come into being.
Had come into being.
All the premiums.
All the orders has been, my lord, served upon NICL. My lord, I'll show it from my contempt application. Let my learned senior.
Yes, ma'am. May I make my submissions?
Address is wrong. Middleton Street, Jawaharlal Nehru Road.
Madam, this is Jawaharlal Nehru Road. National Insurance Company is Middleton Street. Madam, it is unbelievable that a nationalized bank does not even know which insurance company they are dealing with. When there is no insurance company by the name of AICL, I have not heard of. But these are GICs. But this is, my lord, a very sharp practice of adopted by the bank. I'm sorry to make this submission. Unbelievable. They make that is why Justice Sarkar specifically records that NICL is not a party to this petition. Has not been implemented. It is not recorded that NICL has been incorrectly implemented as a party respondent.
Directed the NICL to be approached and then chalk out.
Yes, chalk out the plan.
My lord,
what happened to this, my lord, is that we were not aware of this order because we were
excited.
No, well, I'm not getting excited. I don't get excited. That is
that
is the only advantage I have got. Nothing else. My lord, what has happened is that after this order, when this order was passed, we were already having the order passed by the secretary, principal secretary. Principal secretary has already given a plan. My lord, when the principal secretary's order was not interfered with, your lordship has found from the order. So, my lord, we were acting in terms of the principal secretary's order, where the principal secretary has primarily saddled the responsibility with the bank, concerned bank.
In terms of the bank.
My lord, may I just make this statement? Subject to correction by my learned friend appearing for the bank, they say on oath that they had intimated the bank, intimated the insurance company that they were suffering from some technical glitch for uploading the data. Let them produce before lordship one single communication by email, by writing, whatever.
Certain observations made against you also by the.
But I was not a party.
The right of the farmers for refund have already been.
I was not a party.
Whatever.
Yes.
Right of the farmers for refund have already been upheld by the principal secretary. Scheme also includes a crucial role by the state government. Secondly, NICL cannot ignore the order passed. This order remains.
I cannot.
NICL cannot ignore the order passed by the principal secretary by remaining quiet. Page 16, please just place it, Mr. Mujumdar. Instead of me placing the order, please place page 16.
I'm placing. Well, I'm sorry, my lord. I should have.
No. Why should you?
My lord, may I just read out from page 15? 15.
Very well. Yes.
The last
15 you have already placed. Chalk out the mechanism you have placed. Page 16. From the right of the farmers.
Yes, ma'am. The right of the farmers for refund have already been upheld by the principal secretary. The scheme also includes a crucial role by the state government. Similarly, secondly, NICL cannot ignore the order passed by principal secretary by remaining quiet and by not cooperating with the bank. Thus, direction made herein above should be complied by the authorities and the farmers should not suffer at the hands of non-compliant authorities. The inaction of the bank and NICL cannot be encouraged. The court cannot understand why the NICL cannot rise to the occasion and abide by the order of Principal Secretary, Department of Agriculture. The farmers shall serve a copy of this order upon the Principal Secretary, Department of Agriculture, so that the state authorities can monitor the compliance of this order by bank and NICL. The farmers cannot suffer on account of any mistake of authorities. The NICL has received the premium and they cannot indulge in unjust enrichment. Well, the premium was refunded, whatever was there. It has been refunded. Now, my lord, kindly take the principal secretary's order.
Farmers are suffering.
No, my lord, I am not on that.
In the tussle between you and the
no, my lord, it's not a question of tussle. It's a question of, my lord, approaching the court with clean hands. It's a question, my lord, whether they had at all made any attempt to upload the data.
So, Mujumdar, whatever has happened, what can be done to
the solution your lordship will find in the principal secretary's order. Kindly take the order, which is part of my affidavit.
Which page?
Page 40.
My affidavit, my lord.
Can 1. Lordship may take Can 1 recalling application 51 and 57, both the reason orders in 2 matters.
Yes. My lord, kindly take the order.
Can 1 reason order at Can 1 lordship.
Page 46.
Recalling.
Can
1 in WPA.
Can 1, yes.
In WPA 1 to 8.
No, I'm looking at this 13397.
43 থেকে start হচ্ছে মানে annexure B of this Lal Mohammad opposition.
It's very difficult to cross book.
I am with
it's not there in the Shubham Mohapatra one.
Yes, my lord, sorry.
The one you are placing Shubham Mohapatra, it's not there in the your
lordship has got this. I have handed up a copy of this petition.
No.
Kindly take the your lordship will find the order. Annexed. Kindly take the order. Your lordship will find the order passed by the principal secretary in the writ petition filed by the bank.
Then I have to retain this copy.
Yes, certainly, madam.
So if the file is there, you can find out from the file.
If the file,
Lal Mohammad প্রথম যেটা দিয়েছিলেন সেটা থেকে সেটা এখানেই আছে এই উপরে এখানে আছে
my lord, if your lordship kindly takes, my lord, এটা আমার লাল আমার কাছে আবার লাল
এটা শুভম.
But it is all, in all the oppositions your lordship will find.
That's what I was saying, that if it could.
What opposition, man, your lordship is looking at the file of.
You were relying.
Your lordship is looking at the file of this CPAN number 1996.
I was looking at Shubham Mohapatra, but Lal.
Kindly give me, my lord, kindly, my lord, I will find it out for you, lordship. I'm so sorry, my lord.
Lal Mohammad is 49.
I should have
49.
No, I will find it out from this brief only. It's better, my lord. Lordship is looking at one brief, my lord. I will find it.
It's easier for me.
It is easier, my lord. I'm so sorry, my lord. It's my fault. দাও এটা জজ সাহেবকে বার করে দাও এটা এটা কি এটা আমরা কন্টেম আমাদেরই তো অপোজিশন তাই তো কন্টেম নাম্বার 1 হচ্ছে ব্যাংক আচ্ছা আচ্ছা তারপর তোর বার কর 2 আমরা না এটা আমরা না তা আমাদের অপোজিশনটা কোথায় এটা ক্যানের মধ্যেও আছে very good. Your lordship, kindly. Your lordship will find it as a part of my
page 50
recalling application, page 51.
ওটাই বলছিলাম তো
I'm sorry, madam. And I'm grateful to my learned friend. Page 51.
One is at page 51 and the second is at 57.
এখানে শুরু হচ্ছে পেজ
51 আর second is in order 57.
আমার অ্যাপ্লিকেশন, তাই তো? না, ওতে
এই ডকুমেন্টে আর পেজ আছে
51 went before Justice Sarkar and 57 the mat is pending.
My lord, may I take your lordship, my lord, to pay to the order, my lord. Your lordship has got the order.
Yes.
This is a reasoned order passed in compliance with the order dated 23rd August 2022 by this honorable court in respect of so Durgapada Ghosh and others versus state of West Bengal.
This was after Justice Sarkar's order.
No, this was the order which was challenged.
Challenge before Justice
Because
Sarkar.
my lord, this order is my lord, holds the key to this
Yes,
entire.
Justice Sarkar said that this should be complied with.
This should be complied with. My lord, we are ready to comply with this order. The instant writ petition was filed before the Honorable High Court by the petitioners Sri Durgapada Ghosh and 85 number of farmers, being aggrieved by the inaction on the part of National Insurance Company for not allowing them subsidies by way of refund of insured sum of money as per Bangla Shoshyo Bima scheme of Government of West Bengal for the Rabi season 2019-2020. The Honorable High Court at Calcutta video order dated so-and-so has been pleased to dispose of the matter, directing the petitioners to submit a comprehensive representation before the chairman of the state level monitoring committee, that is the principal secretary, Department of Agriculture, Government of West Bengal, for disposal of the representation by granting opportunity of hearing to all concerned parties, including the petitioners, and passing reasoned order. Accordingly, on receipt of the representation of the petitioners dated 20th August 2023, a hearing was conducted on so-and-so in virtual mode. So-and-so appeared, but that's not relevant. Accordingly, my lord, the branch manager, kindly take, the branch manager submitted his affidavit stating as follows. Bank has deducted insurance premiums from the bank account of 412,376 plus 36 number of farmers and paid to the insurance company in 2 tranches via the UTR number so-and-so dated 31/12/2019 for an amount of rupees 12,12,312 and again, VDA UTR number so-and-so dated 20th February 2020, amounting to 1,27,416. Due to network issue, the bank has failed to upload the data of the farmers in the portal. Bank requested several times to the insurance company, but they did not provide the opportunity to upload the same. Bank also mentioned that these issues were by the letter dated when, kindly the first letter, 2/11/21, as stated therein. The Deputy General Manager, National Insurance Company, via its letter dated 25th September 2023, informed that as per para 7 of the notification issued by the Government of West Bengal during Rabi 2019-2020, farmers' share of premium was 4.85% of the sum insured. Financing bank, the PNB, was supposed to deduct the farmer's share of premium from the bank account of the concerned farmers and send the consolidated amount to the insurance company well before the cutoff date of 31/12/2019. Bank was supposed to send the consolidated declaration, this is important, or proposal of loany farmers to NICL for fulfilling the coverage of potato crop within the cutoff date of 15 January 2020 as per notification of the same. In para 19 of the notification number so-and-so dated 29/11/2019, it is mentioned that the bank will also upload the individual loany farmers data in Bangla Shoshyo Bima portal well before the cutoff date as mentioned earlier, along with sending the consolidated declaration proposal to the insurance company. In this case, PNB Kotolpur, this is the only branch in fact, has neither uploaded any farmers data in BSB portal nor sent any consolidated declaration or proposal within the cutoff date of 15/1/2020 as required. Even today, the insurer does not have any details of any of the farmers of this particular branch of the bank submitted to NICL as per requirement of the notification. Accordingly, NICL did not claim any premium against such farmers not enrolled under BSB, as the premium for that crop season was 14.85% for Bankura in case of potato, and the state's contribution was fixed at 10%. Kindly take my lord, Purapur. The representation dated 28 August 2023 reveals that the petitioners are farmers belonging to Kotolpur block in the district of Bankura. dealing in cultivation of crops which are in the schedule of the notification dated 29th November 2019 for issued for implementation of Bangla Shosho Bima during Rabi 2019-2020 season. They have Kisan credit card account at PNB Kotolpur branch. Passbook entry reveals that the bank has deducted farmers' share of premium from the respective farmers' bank account, which amounts to 4.85% of the sum insured for the period Rabi so 2019-2020. However, the deduction of premium did not specify that premium is meant for crop insurance of this is very important. However, the deduction of premium did not specify that the premium is meant for crop insurance of Bangla Shosho Bima scheme. Accordingly, after receiving the said affidavits from the concerned bank authorities and insurance authorities, second and final hearing was called on 10/10/2023 through virtual mode, involving the petitioners so and so, so and so, so and so. During hearing, bank authorities submitted that they had deducted the due premium in respect of the present petitioners for Rabi 2019-2020 season, but unable to upload the relevant data in the BSB portal before cutoff date, even within the crop season due to some technical difficulties. On inquiry, they have admitted the fact that they did not prepare the list of farmers whose premium was deducted by them, and as such did not forward the said list to NICL. They never submitted the details to NICL or to the authorities of Agriculture Department within the cutoff date, not even within crop season. They allege that NICL neither allowed them to upload data nor returned the farmer's share of premium paid to it. However, it was revealed from the records of the Agriculture Department that NICL did not ever claim the state share of premium subsidy receivable from the state government, that is 10% out of approved premium of 14.85% for coverage of those farmers of PNB Kotolpur. The representative of NICL argued that part payment of insurance premium without uploading farmers list and requisite documents in respective portal does not confer any right to get coverage and claim compensation against the sum insured. The representatives of the petitioners who are among the affected farmers ascertained the fact that despite payment of their share, they are yet to receive their benefit of claim compensation. They allege that the bank authorities are silent in this regard. They accepted that many of them got the claim under BSB Kharif Rabi 2021 in next season when all formalities as per the scheme were duly complied. After hearing the parties, careful consideration of the representation of the petitioners, written statement, affidavits of the bank authorities as well as NICL, I am of the view bank authority has deducted the farmer's share of premium from respective bank account and paid to NICL without mentioning that the premium were deducted and deposited for coverage of BSB Rabi 2019-2020 season. Bank authority has failed to upload the farmers' data in BSB portal as well as to prepare the detailed list of farmers for submission to NICL and authorities of Agriculture Department within cutoff date, even within the crop season. Bank authorities has failed to discharge their duty as mentioned in a notification issued for implementation of Bangla Shosho Bima scheme for the benefit of the farmers of the state. It was revealed from the records of the department that as per guidelines of BSB for Rabi 2019-2020, state government has to pay 10% of the sum insured as the state share of premium, which were neither claimed by NICL nor paid to them by Agriculture Department. From the submission of parties was revealed that NICL failed to claim the state government share in the absence of any list of farmers of PNB Kotolpur branch forwarded to them or uploaded on the portal as per para 19 of the notification. Amount deposited to NICL by PNB Kotolpur branch towards farmer share of premium is still lying unutilized in their account as no specification or declaration was provided for finalization of insurance proposal. However, farmers of PNB Kotolpur branch are entitled to get insurance benefit as crop losses occurred in that crop season, and bank deducted crop insurance premium for the loan account with the assurance to extend insurance of the crop secured under the bank loan. Therefore, it is concluded as follows. As per notification dated 29 November 2019, the seasonality discipline was mentioned in para 7, and as per para 19 of the said notification, the bankers are to provide details of the insured farmers list along with consolidated declaration proposal to NICL and should also upload the relevant data in the BSB portal as well before the cutoff date. As no information has been uploaded and no payment of state share of the premium has been claimed by NICL or released to NICL in favor of the petitioner, no insurance under BSB scheme has been done, against the petitioners for Rabi 2019-2020 season. Therefore, the petitioners are not covered by BSB under BSB for Rabi 2019-2020 as payment has not been made as per the operational guidelines of BSB scheme and notification of Rabi 2019-2020. The concerned authority, NICL and bank authorities are required to refund of share of premium paid by the petitioners with interest as applicable within 1 month from the date of receipt of this order. Farmers are entitled to get for their crop loss from the bank who deducted premium from loan. It is observed that there were latches from the end of the bank authority PNB Kotulpur for coverage of the present petitioners, loany farmers of PNB Kotulpur branch under crop insurance despite deducting the contribution of farmer shares of insurance premium for the petitioners concerned. For adjudication of such dispute, it is beyond the mandate of the state government or agriculture department. The bank authority is hereby advised to settle the issue with the petitioners as per banking norms and extend suitable compensation to the affected farmers. In this context, the branch manager PNB Kotulpur is requested to complete the process of settlement of payment of compensation to the affected farmers within 2 months from the date of receipt of this order. We have refunded that amount. That is admitted by the bank also. So now it is for the bank to settle this account.
These loans were taken by the farmers from different banks, not necessarily from this.
No, Mala, this is, we are concerned with Kotulpur right
Jurisdictional.
now. Jurisdictional bank, Mr. Galib is absolutely.
That the mechanism of this is that the farmers take loans.
Yes.
And insure the loans. I mean, if there is a loss.
Yes. There is a Kishan credit card, my lord.
Yes.
Kishan credit card is there. There is a account maintained with the bank. Whatever balance is available in the with the bank, my lord, from that the premium is deducted. Premium is to be transmitted to the NICL.
After that, what happens?
After
what
that,
is insured?
what is the issue is that after that, what is required to be done is that they should upload a consolidated statement.
No, that I have understood.
Yes.
But after, how does the insurance? I mean, how does
how does it work? Suppose, my lord, suppose, my lord, what happens? Suppose, my lord, suppose there is a loss during one particular crop season.
Yes.
Then, my lord, for that loss, whatever loss is occasioned, the insurance amount or the amount to be paid is insured by the respective insurance companies. Then, my lord, whatever loss is occasioned, that is covered. Whatever payment is to be made by
whatever the payment the farmers have to make, you cover that and you make those payments.
Yes.
If there is a valid.
If the farmers are entitled to get that compensation, then that is covered. Well, likewise, my lord, today, if somebody purchases a property, for example.
Their protection, the farmer's protection is that the money which they are liable to pay.
They are not in a debt. They don't fall into the debt trap. Yes. They don't fall into the debt trap. And the entire is our owners in terms of the order of this principal secretary order, which has not been interfered by Justice Sarkar, is that we have to refund the premium.
But that arises only if there is a loss on.
Naturally, well, it is their case of the petitioners
that they have suffered a loss.
Yes, they have suffered a loss.
And that amount, that up to that extent, the loss.
But we are not in a position to assess the loss because we were not informed. But the direction is very clear, and this order still stands. And our whatever Justice Sarkar observed, that we have to act in terms. We immediately refunded the premium amount as required by this order. Well, if you do lordship like to have a look at this object of the scheme and the loss, how this scheme works. Kindly take, my lord, the scheme.
Page 16 of this. 1/6.
Kindly take. এটা থেকেই দেখাচ্ছি এখান থেকে এটা থেকে দেখাচ্ছি একই ব্যাপার না জজ সাহেব তখন তো অ্যাপ্লিকেশনই দেখছে
16 minutes.
It starts from page 16. My lord will kindly take
all this are there sum insured premium.
Your lordship. Huh? 9 আছে তো okay. Kindly take, my lord, the introduction. Your lordship will get a clear picture. Agriculture is the main source of livelihood of about 70% of the population of West Bengal. There are about 72 lakh farm families in the state, 96% of whom belong to the small and marginal category. The cultivable area is about so and so hectares, 56 lakh hectares, out of which 52 lakh hectares are under the plough. The cropping intensity is around so and so 184%. The West Bengal is the leading producer of paddy and jute and the second largest producer of potato. Cultivation of pulses and oilseeds has expanded considerably in the recent years. The diverse agroclimatic zones and available resources coupled with hard labor of the farmers has made this agricultural advancement possible. However, the state is wrought with vagaries of nature like flood, cyclone, hailstorm, drought, etc., which often pose serious challenges to the farmers. It is thus necessary to adequately indemnify the farmers from crop losses due to such unforeseen calamities and to compensate them in the event of occurrence of such losses and to keep them motivated towards farming. The government of West Bengal has participated in all centrally sponsored crop insurance schemes. Well, the schemes are spelled out in the right earnest and has come also borne the farmer's share of premium since 2012 to motivate the farmers towards crop insurance. However, timely claim of settlement to the affected farmers has not always been possible. As the central sponsored crop insurance scheme is governed by the central government guidelines, the control of the state over the settlement of claims and adherence to timelines is limited. Government of West Bengal has thus launched Bangla Bishwa Bima scheme, Shosho Bima scheme, and a wholly state-funded scheme with an aim to extend hassle-free benefits of crop insurance to all farmers of the state and to ensure timely claim settlement following a transparent and simplified procedure in the event of crop loss due to insurable risk. The operational guidelines of the schemes are detailed below. Now, we'll kindly take page 16 for once. I will give you, Lordship, the clause.
Internal page 8.
My lord, kindly take, my lord, loany farmers under the internal.
Page 24.
Well, it may be page 24. My lord, the heading is loany farmers compulsory coverage. My lord has got that. But this is how your lordship will get a clear picture what actually happens. Whenever banks sanction loan for a notified crop in a notified area, the crop loan amount is only to the extent of scale of finance for notified crops, and acreage of individual notified crops of loany farmers shall be taken into consideration for compulsory coverage as per seasonality discipline. Based on the seasonality of crops, banks should separately calculate the eligibility of loan amount for both Kharif and Rabi seasons based on the scale of finance and declared acreage under the notified crops. Disbursing bank branch or PACS will prepare monthly statement of crop-wise and insurance unit-wise details of crop insurance with premium as per the seasonality discipline. Loan disbursing bank branch PACS will finance the additional loan towards premium amount payable by farmer for crop insurance for potato and sugarcane. Crop loans through Kishan credit cards are covered under compulsory coverage, and the bank shall maintain all backup records and register seasonality, discipline, and cutoff date for submitting declarations in case of normal crop loans. Bank branch will apportion coverage amongst insurable crops based on acreage mentioned in loan application or on the basis of actual area sown as declared by the farmer subsequently. Bank branches of commercial banks, RRBs, nodal bank in case of PACS under its jurisdiction shall consolidate, but this is the requirement, consolidate insurance proposal or statements from their bank branch under or PACS under its jurisdiction respectively and forward the same to the insurance company along with the details of remittance RTGS towards insurance premium in accordance with the cutoff dates specified by the state government for that particular crop or season. Now, Miller, kindly take clause 12 for once. But this is page 20. This is non-loany farmers optional coverage. This directly to insurance companies. Then, my lord, kindly take the working of the scheme. Kindly come directly to post-harvest losses. This is page 15 of the scheme. My lordship will kindly take the internal page, which is at the bottom of every page. Pagination.
Yes.
Post-harvest losses. It is proposed to provide for assessment of yield loss on individual plot basis in case of occurrence of cyclonic rains, and unseasonal rains throughout the state, resulting in damage to harvested crop lying in field in cut and spread condition up to a maximum period of 2 weeks, 14 days from the harvesting of for sole purpose of drying. Eligibility criteria available to all insured farmers at farm unit level affected by above mentioned perils in a notified insurance unit growing notified crops for which insurance have been availed. Available for all crops damaged by specified perils which are left in the field after harvesting in cut and spread condition for drying up after a period of 14 days. Now, the loss assessment procedure has been detailed. How it is to be reported. Kindly take, my lord, first, time and method of reporting the loss or claims. Immediate intimation within 48 hours by the insured farmer to anyone as detailed below. Intimation must contain details of survey number wise insured crop and acreage affected. Premium payment verification wherever applicable to be reported in next 48 hours by farmer or bank.
No,
Whom-
Mr. Mujumdar, what I'm asking you is that
Yes,
this insurance scheme will cover only the loan repayments.
it will cover, my lord, it is, my lord, season-based loan, seasonality-based loan.
So bank gives a loan in the first place, they buy
Yes, my lord, the loan
seeds
has
and
to
all
be,
with
my lord,
that.
the loan amount, the entire loan amount, but it is sum insured is basically the loan amount. Either whole or full. My lord, it may be partly or maybe partly, maybe fully. My lord, it
So
may be in
whatever
part or
party is
maybe-
insured, I mean, if they suffer a loss and cannot repay that loan,
Yes,
you pay that for them. If
Yes,
there's a
yes.
valid insurance.
yes, my lord. We will secure the, my lord, the compensation has to be paid by my lord, by the bank so that, my lord, they do not suffer loss on their own account. Otherwise, my lord, suppose if there is a loan, they will not be able to, they will be caught in the debt trap.
Right.
But the payment is made to the
Mr. Mujumdar, I have a bench with Justice Shen.
Right.
We'll continue after 2.
Yes, ma'am. We'll come back. Sharp notice, and we have deposited the cost, and that apart, they have filed their affidavit in
Cost for what?
opposition. Cost for special messenger Tolobana for
Rule issue.
no service of notice. And this is our reply.
Rule issue limited. Rule issue. Rule issue. What was the alleged contempt?
Kindly allow me to check it, because twice affidavit in opposition has been filed. I have to check it to which opposition it has.
Affidavit in opposition filed by the container number 2, my lord.
এটা ফেরত দিন।
18 নভেম্বর না?
ফেরত দিন।
ঠিক আছে। আর এটা হচ্ছে হ্যাঁ, ইয়েস, ঠিক আছে, এটা ডিসেম্বরে। ঠিক আছে।
রিপ্লাই বলছে।
Affidavit in opposition have been filed.
Yes, my lord.
We are filing today.
This is my affidavit in compliance.
You are appearing for?
Counter number 1.
Against whom rule has been issued?
Not against one.
Against whom? Against your client rule was issued.
My not mine.
Rule was issued only against your client.
My not.
Yes.
Is there, my lord?
কি অর্ডারটা ছিল? Parent order. What was the parent order?
Now, my lord, kindly take up page 46.
With regard to a repairing matter?
Yes, yes, my lord. That repairing matter, page 46 of my contempt application, annexure P3. This is the parent order, my lord.
What is the operating part, sir?
My lord, operating part, my lord,
What
start
did they
from
do? They registered.
From page.
No. Kindly see, my lord, they have taken that order. We applied for before the municipality. Municipality, my lord, directed us to submit an undertaking. We have submitted an undertaking.
What did
And
they do?
And thereafter, no, municipality passed a 2-line order that yes, you are permitted to raise construction.
What did they do?
They filed an application under section 163 of BNSS, that is, Lord,
Equivalent to 144.
144. The learned judge, the learned subdivisional officer sitting under his jurisdiction of 144 of the Code of Criminal Procedure stayed my lord's order.
He was made aware about the order of the High Court.
Kindly see his order. What he says, he says he is aware.
Whether the contender number 1 was made aware.
Yes,
of the order
says
Sir,
that
please listen to us, then answer. Whether the magistrate was made aware by the petitioner of that proceeding, that such and such order has been passed by the High Court. Or not.
Yes. Kindly see the application under section 144 CRPC at page 54.
54 of the contempt application.
Contempt application.
Kindly please.
Yes, my lord, kindly come to 7 lines from top. সেই মর্মে রামপুরহাট সিভিল জজ সিনিয়র ডিভিশন প্রথম আদালত যাহা টিএস 105/2006 ফাইনাল ডিগ্রি প্রদান করিয়াছে, উক্ত ডিগ্রি জারির আদালত মোকদ্দমা পেন্ডিং রইয়াছে। প্রতিপক্ষ দরখাস্তকারীকে হয়রান করিবার জন্য মাননীয় উচ্চ আদালতে ক্যান 2 অব 2024 মোকদ্দমা দায়ের করেন। উক্ত মোকদ্দমায় উক্ত আদালত রামপুরহাট মিউনিসিপালিটিকে বিবেচনা করিবার জন্য পাঠাইয়াছেন, কিন্তু মিউনিসিপালিটি উভয় পক্ষকে না ডাকিয়া বা কোনরূপ স্পট এনকোয়ারি এখনো করে নাই বা উক্ত কার্য করিবার কোন রকম কোনো অনুমতি প্রদান করে নাই। So, my lord, there is an order passed in a proceeding in Can 2 of 2024. It has been placed before the learned magistrate there.
We are directed to permitted to repair. They have stated that
my lord.
That is
উক্ত মোকদ্দমায় উক্ত আদালত বিবেচনা করার জন্য পাঠিয়েছেন।
Yes, that is why, my lord, contempt number 2 has been my lord added as a party.
আমাদের প্যারাগ্রাফ 8 টা দেখুন স্যার, পেজ 48।
মিউনিসিপালিটি তো দিয়ে দিয়েছে পারমিশন,
রিকোয়েস্ট পারমিশন
দিয়ে দিয়েছে, কিন্তু সেটা তো টেনার অফ দি অর্ডার নয়। পারমিশন আমরা বলেছি অ্যাপিরেন্ট পারমিটিং ইজ উই পারমিটেড দি অ্যাপিরেন্ট টু ক্যারি আউট দি রিপেয়ার।
হ্যাঁ, অ্যাবসলিউটলি।
আমাদের প্যারা 9টা দেখুন,
অ্যাবসলিউটলি
আমাদের ডিসপ্লের প্রশ্ন উই পারমিটেড
And my lord,
ক্যারি আউট, এটা সাবজেক্ট টু মিউনিসিপ্যালিটি। হ্যাঁ, মিউনিসিপ্যালিটি দিয়ে দিয়েছে।
রিকোয়েস্ট পারমিশন ফ্রম দি অ্যাপিরেন্ট।
Let us see the order of the
yes, that is, my lord, at annexure P8 at page 56. My lord, kindly see the order at the bottom portion of page 58, handwritten order.
Page 58.
My lord, yes, my lord, page 56, annexure P8. It is written, if I am not wrong, my lord, it is written by the very contemptor number 1 himself in his own handwriting.
Kindly please.
The EO Rampurhat municipality is directed not to issue any permission from their office to the opposite party on the basis of conditional order of the Honorable Kolkata High Court Bhaidi given or particularly in because the matter is sub judice for given being number 1 of Atho in the court of learning. So
directed not to issue any permission from the
yes, he is directing the municipality not to issue any order pursuant to the order given by the High Court.
Because the matter is
conditional order of the High Court. On the basis of the conditional order of the High Court.
They are WBC's officers.
My lord, how can I say?
Where is he?
My lord, may I submit, my lord? My lord, he is there. My lord, may I submit, my lord? The
Yes.
fact is otherwise. My lord, the next page, which has probably not been annexed, indicates that upon receiving of a complaint and an application under 163, indicating that in the garb of repairing, reconstruction has been started, we have only directed the municipality to conduct an inquiry to stop the work for the time being and directed the police, my lord, to stop the construction. If your lordship kindly comes to page 20 of my report, my lord, just for once.
Mr. Ghosh, please. That is post facto. But when you receive the order, you pass this order. The EO Rampurhat municipality is directed not to
My lord, we
issue-
have passed.
Please, 1 minute. Is directed not to issue any permission from such and such on the basis of conditional order of the Calcutta High Court. How
Milord,
dare he?
this order is continuing because, Milord, the order
How
was
can he say that you won't grant permission on the basis of, he directs the municipality not to grant any permission
because,
on
Milord,
the basis of the order of the High
because
Court?
the order was violating paragraph 12 of your
Sir, is it
Lordship's order. Your
Sir,
Lordship, kindly may I read it
another
out?
point?
May I read it out?
Kindly place the
The operative postal
relevant
which-
provision.
My lord,
BNS,
Milord,
BNSF.
Milord, kindly let me place the order which was being violated by the petitioner. Your Lordship,
That is not
paragraph 12.
reflected here.
Milord,
On 30th
No,
of
Milord,
January 2025
the
order is
next
not
page,
reflected.
the next page has not been annexed.
Page 57
20.
is there.
No, but no, the next page of the order sheet, which is there in my report, Milord, which category, my lord.
Let's see that. Have you report file করেছো? Affidavit of compliance. Which page, Mr. Ghosh?
Milord, page 20. Because this order we have passed, since we have received information that paragraph 12 of the order passed by on
Yes, it is there in their copy also.
was being
No, this is there in their copy also.
my lord. And Milord,
Next
the
page is
IC
there. Why are you relying on your copy? We have the.
and Milord, the IC
Why are you saying that it has not been placed, Mr. Ghosh? It has been placed. The very next page gives the next page of the order.
But he has not indicated it.
What indicated?
Milord, that the EO, inquiry officer, also directed that before issuing any permission to the opposite party, if applied, the hearing should be taken from all the interested parties to make the matter transparent. And Milord, the fact is that thereafter municipal
Who is he to say so? He is modifying our order.
No, Milord, because we have received complaint and admittedly.
Whatever you have received, Mr. Ghosh, please come back to our order.
My lord.
How dare he?
Milord, this order.
Please come back to no. Please come back to our order.
My lord. From para 10 of your lordship's order. Para 10. Para 10.
Page
Not
Page 46. It starts from page.
Para 10, Milord.
46 of this.
Milord, it is there also in my report, Milord.
Yes. We direct can is disposed of by permitting the appellants to carry out the necessary repair works as indicated within a period of such and such. Insofar as point number A, the appellants are permitted to undertake the same subject to sanction being obtained from the concerned. So we permit him to repair subject to the sanction being obtained from the municipality
for repairing,
and entire repair construction work is indicated shall be completed within such and such. In para 8, we observe that since the repair sought in paragraph number 4, that is reconstruction, may tantamount to a reconstruction. For that purpose only, we said that which requires permission from the local municipality, the said reconstruction is to be permitted subject to sanction in that regard if necessary in law. So we permit him to repair subject to sanction by the municipality. Municipality has you say that the municipality won't sanction.
No, your lordship kindly comes to paragraph 12 as well of your lordship's order.
Yes.
It is categorically clear that in the garb of such repair, reconstruction, the appellants shall not alter the nature and character. And Milord,
that is our order. If he violates, they'll come in contempt against that to us.
But Milord, the municipality has made an inspection, inquired, and Milord admitted it was found. Your lordship kindly takes the last page of my report, Milord. Municipality has stopped the order, and we have directed the police to stop any reconstruction.
No, not that, Mr. Ghosh. We are not on that at all. How can you say that the Rampurhat municipality is directed not to issue any permission from their office on the basis of the conditional of the order of the Calcutta High Court?
Because, Milord, the condition was that because we have received specific complaints, Milord, that
in the garb of they are permitted to repair subject to sanction being obtained by the municipality, right? So municipality will only consider whether they are entitled to sanction.
My lord.
It's between them and the municipality, nothing else.
But before approaching the municipality, with the help of this order passed in this FAT, they have started the work. And soon thereafter, my lord, we have received a complaint. We have received a complaint that in the garb of repairing, reconstruction and change of nature and character is being done. We have approached the municipality, my lord, to stop the work for the time being, and my lord, to cause an inquiry. And we have requested the police to stop the construction work, not the repair. And thereafter, my lord, the municipality, my photographs are also
modifying our order. You are saying that You don't say that in your order. You say that the EO Rampurhat is directed not to issue any permission on the basis of this court's order.
In terms of the conditional order, because my lord, we have this information that the order was being
Had it been such a case,
they would approach us.
That your client asked the police authorities to take appropriate steps to stop the
construction.
illegal construction. We
That
could
has
have
been done.
understood.
That has been done.
We could have understood.
Did not give that liberty to anybody.
My lord, we haven't approached for any.
No, from page number
of the repairing.
24, page number 24, we find there are some materials that they on during inspection, Rampurhat municipality notice that in the garb of repair they are going making an illegal construction.
My lord. That is
But
the main
your,
issue, my lord.
but your order does not reflect that. That is
My lord, the
difficult.
construction of the sentences are wrong, my lord, admittedly.
Your
But, my lord, the intention, because, my lord, we have
not to issue any permission.
my lord, the,
It is an utter violation of the order of the High Court.
my lord, the sentence construction is wrong. I admit, my lord. But, my lord,
You are a
it is-
WBCS officer. You're not a rustic villager.
my lord, that is admitted, my lord. The
How can you
construction is wrong.
attribute sentence construction being wrong? Your intention was not correct.
My intention was,
stay.
my lord, only to comply,
Absolutely.
strictly comply the order of this honorable court. So that
On the contrary, Mr. Ghosh, your client says directed not to issue any permission from the your office on the basis of the order of the
in
conditional
view of
order.
the complaint, my lord, that we have
You
received.
have not stated there.
My lord, it is. My lord, the
It's not
complaint is there.
reflected.
My lord, we
The
have,
EU is also directed that
Milord,
before issuing any permission,
my lord, we have,
if applied, the hearing should be taken from all the interested parties. Who is he to say
my
these
lord, this
things?
160 application.
Municipality will decide that.
My lord, the 160 application has been filed before us, indicating about allegations that in the garb of repairing the building, my lord,
Sir,
armed by the order of
prayer
this
is
court.
page number 18 of your report. Kindly come.
My lord.
Just prayer portion. মতের প্রার্থনা দয়াপূর্বক হুজুর বাহাদুর উক্ত অবস্থা বিবেচনা করিয়া যাহাতে প্রতিপক্ষ কোনো নতুন কনস্ট্রাকশন করিতে না পারে।
Yes.
আমার জায়গা থেকে বেদল
New construction was barred, my lord. My lord, new construction was barred by the order, paragraph 12. My lord, it is there not by compliance. নতুন ভাবে construction. It's a fact, my lord.
আচ্ছা আচ্ছা Yes.
This my lord, this নতুন ভাবে construction was stopped. Because, my lord,
if I ask for A, you will grant prayer B.
No, my lord, we have only approached the municipality so that this নতুন ভাবে construction is stopped, and we have requested the police to stop any construction, not the repair one. It is also on record. It is also on record. My lord, it is on record. It is on record, my lord. Page 20, paragraph 2. The IC Rampurhat PS is directed to stop the construction
That is
of the OP,
subsequent.
not the repair.
That is subsequent.
Same order, same
We
order.
are on-
This is the part of the same order. This is the part of the same order, my lord.
দেখুন একটা জিনিস আপনাকে বলি।
This is the part of the same order.
This person is not the authority to decide. Municipality কে আমরা বলেছি ও রিপেয়ার করবে subject to sanction from municipality. Municipality is the only authority which can sanction. এখানে এই যে অর্ডারটা রয়েছে এটাতে তো মিউনিসিপ্যালিটিকে সেই এক্সারসাইজটাই করতে বারণ করছে বলছে the EU Rampurhat municipality is directed not to issue any permission from his office to the OP on the basis of conditional order of the Honorable High Court.
Because it was being violated.
বলেছি পারমিশন দিতে আমরা বলেছি পারমিশন স্যাংশন দিলে তবে করবে আর ও বলছে যে
দিও না।
ডিরেক্টেড নট টু গিভ এনি পারমিশন শুধু ডাজন্ট স্টপ দেয়ার টু দ্য অন দ্য বেসিস অফ দি কন্ডিশনাল একটা কন্ডিশনাল কথা ঢুকিয়ে দিল অন দ্য দাঁড়াচ্ছে কি হি ইজ ডাইরেক্টিং দ্য মিউনিসিপ্যালিটি নট টু গিভ এনি পারমিশন অন দ্য বেসিস অফ দ্য অর্ডার অফ দিস কোর্ট
My lord, the fact is that since we have received the complaint about,
you should have sought a clarification from us. Not only stopping there, the EU is also directed that before issuing any permission to the OP, if applied, hearing should be taken from all the interested parties. 163.
Spirit of the
my
one.
lord, your lordship knows, my lord, under 163, my lord,
You are usurping the jurisdiction of the High Court. You are usurping the jurisdiction of
since we have
the
received
civil court.
my lord, since we have received the complaint of নতুন ভাবে construction, changing the nature and character of the building, we have only approached the municipality to cause an inquiry, and subsequently inquiry revealed
Sir, we are
that they were
seriously-
violating the order.
We are
The photographs
seriously
are there.
thinking to remove him from the post.
My lord,
He is unfit for the sitting in the
my lord,
post.
If he doesn't understand this much of an
my lord,
order, he is not fit to be in his
my
post.
lord, this construction of this order is wrong, admittedly, my lord. I'm admitting it. And I'm bowed on.
What construction? He
But
says
Lord-
we direct them to give permission. Give subject to sanction, they'll repair.
My lord.
And municipalities to give sanction if otherwise they are permitted.
My lord, but the essence
He
is
says municipality would not give permission on the basis of the condition of the
because,
court.
my lord, we have received the complaint.
No, because
about
if there,
newly, my lord, it is
even
there.
if there was a complaint, Mr. Ghosh,
That-
even if there
newly-
was a complaint, you could not do this. Even if there is a complaint, you cannot, by virtue of 163, override the specific direction of the High Court under 226.
My lord, we
You
haven't
cannot do
stopped the
that.
work. We have
If
only
your
approved
order
the-
is in conflict of 226 direction, you cannot do that.
My lord,
Either you could seek a clarification from this court, or you could just say it has been subject to the scrutiny of the High Court. High Court direction is there specifically. We have asked him to permitted him to make repair.
But that was,
He
but
will
that
make
was
the
being
repair.
violated. That was being.
You have not said that.
You
You have not said a single line on that in this order.
We haven't stopped the work. The work have been stopped.
You
by
did not
municipality.
state a single reason for doing this. You say you have the guts, Mr. Ghosh, to say that you don't comply with the order of the High Court. You say do not issue any permission on the basis of the order of the High Court. How dare he does it? We'll send him to prison from here.
On the basis of the.
He's not fit to be in his post.
On the,
Come on, no.
on the basis of the complaint. On the
What
basis of the
complaint?
complaint.
Forget your complaint. No complaint is reflected here. Not a single line of complaint is reflected in this entire order. Show us where he has stated. Show us where he has stated about complaint. Please show us.
This order is passed in connection with the miscase.
Whatever connection. We are oblivious of any connection. He says that the EO Rampurhat municipality is directed not to issue any permission from his office on the basis of the order of the High Court. And then he sermonizes. EO is also directed that before issuing any permission to the OP if applied. Have we said this in our order?
No. For 1 minute,
He has not
Just
stated
for 1
anywhere.
minute,
No.
Just for 1 minute, Milord. Your Lordship, this misdemeanor case is, Milord, in connection with misdemeanor case number 248. And Milord, page 17.
He is aware of the order of the High Court. We have granted him permission subject to sanction. He cannot say that on the basis of the order of the High Court. We have said municipality will sanction subject to his compliance of the other law. And he says, he directs the municipality. You won't issue a permission on the basis of the Calcutta High Court's order. And you are defending this order, Mr. Ghosh. This recalcitrant client.
Milord, I am not defending, Milord.
You are there to defend him.
Milord,
You are an officer of the court.
My Lord,
No.
since, my Lord, Milord, kindly allow me to submit, Milord. Since we have, Milord, since we have received the Milord, kindly, Milord.
We'll send
Milord, kindly. This construction of sentence.
These people should not be permitted to go scot-free.
Milord, this.
No, these are the kind of people who laugh at orders of the High Court because of our because of our toothlessness. Because we don't take any penal action, they get scot-free and they'll go out of the courtroom, Mr. Ghosh, and they'll brag to their friends that orders of High Courts are for the dustbin.
Milord, we are tendering unconscious apology. What, Milord? Our
That's lip
intention
service.
was.
That's it. You are not at all apologetic.
Milord, our intention.
You thought yourself a king in your own throne when you passed this order.
Milord, our intention was never to violate the order of the court.
Your intention is evident from your order itself. How can you say, even say this, not to issue any permission, and you say on the basis of the condition of the order of the High Court?
Upon receipt of the complaint. Upon receipt of the complaint that a newly construction that
It would be prudent. It would be prudent if you pass an order directing the police to see that no illegal construction is.
that we have done. That we have done.
That would
Construction.
otherwise.
That we have done.
But how dare you to say the municipality not to grant permission?
Because, Milord,
utter contempt.
Milord, I am just praying unconscious apology, Milord. But Milord, the fact is that, Milord, we have got no intention. We won't dare to violate the court's order, Milord. I am just tendering unconscious apology, Milord. But since we have received categorical complaint that the as of now, he is posted to Bankura. And Milord, since we have received a specific complaint of Notun Kore construction, we have only up to the Minister of Milord to cause an
We're
inquiry.
only considering whether it should go in his service book or not.
My
Regarding
lord,
the
my
penalty,
lord,
we
I
have
bring-
already made our mind.
Milord, I have bring the unconscious apology,
Made
Milord.
up our mind.
The construction of this sentence is absolutely wrong. But Milord, we have got no intention to violate order, Milord. We don't have that audacity even. And Milord, we have got no personal.
Of this act, the work which is proposed to be done,
My lord.
which is permitted to be done, has been stalled.
Because
And we are not talking about the alleged illegal construction.
My lord.
We are talking about the repairing which this High Court
Because he was not repairing, Milord. Of the order, Milord, in view of the complaint, there are newly construction is being done. And not admittedly, they were violating the order. The municipality caused an inquiry. Photographs are there, Milord.
May I submit one thing, my lord? Only one.
They have admittedly violated the order.
Before starting, my lord, kindly see this.
Madam, the difficulty on your part is
Only
all.
kindly see. For a second.
What?
Stamp reporter report. Kindly see.
What stamp report?
Kindly see, my lord. Back page of the stamp report. There was a delay of 5,175 days delay in filing the instant appeal arising out of which the present proceeding is pending before appearing. The appeal itself filing in delay.
Which appeal?
This instant appeal out of which
We are hearing a contempt matter.
We are hearing contempt.
appeal is
Can we reopen our order in contempt? You are now taking a point that the appeal was barred in which the order was passed.
No, my lord, that's why, my lord, may I be permitted to file one application for review, my lord? Kindly come without certifying.
No question of that. Post facto, you are not getting. And
kindly-
why did you not comply? What is your answer to this?
Yes, my lord, I have filed under compelling circumstances to maintain the peace and tranquility. I have to take records of the under section 163, my lord. Since the appellant is 65
Your
years
contempt is only against the
Both of them.
both of them. What-
residing, my lord. He was alone, along with his wife. He was residing. His sons was stays outside, out of state.
So when is the municipality taking care of the wives of people?
No, my lord, kindly see.
You are directed to consider grant of sanction. Did you grant the sanction?
No, my lord. that
Why?
is not- My lord, I have since the contempt, the excavation was just my adjacent ward of my residential.
What was our direction?
Yes, my lord, that is true.
What was our direction?
Repairing, but
No. We not only that, not only repairing, we permitted you to subject to sanction by you. So did you consider the sanction? Did he apply for sanction?
You are appearing for whom?
Municipality.
No.
I responded number 1.
Who is the person মানে যে approach করেছে?
Oh.
And Milord, your lordship
Who
kindly.
is for the municipality?
No, municipality has not been made a party in the contempt.
And your
That
lordship.
is what we asked you. The contempt is against both of them, or
No, both of them means, my lord, the respondent and the learned officer who passed the order.
And Milord, admittedly, it was found, Milord.
respondent. What was his contempt?
He has filed his application under section 144.
Under compelling
And my lord,
circumstances, I
he
must
sought
comply
for,
to
my lord, stay of the order passed by the honorable
Your
division bench.
lordship's order was only repair the suit property, not
Just
to.
a minute. When judges are talking,
Yes.
it is a
Yes,
minimum
I-
expectation.
affidavit in opposition.
The present contempt application has been filed alleging the violation of an order passed by this court on December 16, 2024 in Can 2 of 2024, an application for repair filed in respect of FAT 70 of 2023. In paragraph number 8 of the said order, this court had recorded that since the repair sought in paragraph number 4 within bracket small a, that is the reconstruction on the ground floor roof, may tantamount to a reconstruction which requires permission from the local municipality, the said reconstruction is to be permitted subject to sanction in that regard, if necessary in law, being obtained from the local municipality. So next para. Thereafter, this court disposed of Can 2 of 2024, the repair application made by the present petitioner, by permitting the appellants within bracket present petitioners, bracket closed, to carry out the necessary repair works as indicated in point numbers sub small bracket B, C, D, E, and F of paragraph number 4 of the application within a period of 4 weeks from that date. Next para. We further clarified that insofar as point number small a within bracket in paragraph number 4 is concerned, the appellants were permitted to undertake the same subject to sanction being obtained from the concerned municipality, if so required in law. The entire repair to reconstruction work as indicated in paragraph number 4 was to be completed within 8 weeks. Next para. We further clarified that in the garb of such repairs to reconstruction, the appellants shall not alter the nature and character and or the physical possession in respect of the suit property as on that date, and the appellants, by virtue of such repair, shall not claim any special rights or equity in the suit property in any manner at any stage of the suit. The repair / reconstruction work was to be done by the appellants at their own cost without claiming any benefit. Next para. The allegation is that the alleged contemner, that is the concerned executive magistrate, on the basis of an application filed by the alleged contemner, on the basis you have not made him a contemner.
Pursuant to the leave granted by your lordship, we have made him a party. Respondent number,
Pursuant to the application under section 163 of the BNSS filed by the added contemner number.
Bhuvaneshwar Shah is the added contemner number 2.
Magistrate 1.
Magistrate is 1.
Added contemner number 2, passed an order dated January 30, 2025, directing the O Rampurhat municipality not to issue any permission from his office to the opposite party within bracket present petitioner, bracket closed, on the basis of conditional order of the double inverted mode Honorable Kolkata High Court, double inverted close, vide FAT number 70/2023, তারপর double inverted মধ্যে, because the matter is sub judice for title execution case being number 1/2023 in the court of LD civil judge within bracket SR div senior division short form, bracket closed, first court at Rampurhat, and the petitioner has also obtained the final decree from the Rampurhat Civil Court, vide TS 100/2006, double inverted close, full stop. Proceeding further, the alleged contemner number 1 directed the EO of the said municipality that before issuing any permission to the opposite party within bracket present petitioner, bracket closed, if applied, the hearing should be taken from all the interested parties to make the matter transparent. Full stop. Next para. Furthermore, the contemner number 1 directed the I/C Rampurhat PS to stop the construction by the OP at once as alleged, if any is being done till the disposal of the existing suit as pending in the Rampurhat Civil Court. Full stop. Next para. The allegation before us is twofold. First, the added contemner number 2 had filed the application under section 163 BNSS in violation of the order passed by this court. Secondly, that the contemner number 1 has, also in willful disobedience of the order of this court, directed the EO Rampurhat municipality not to issue any permission from his office to the present petitioner on the basis of conditional order of this court. Next para. Upon hearing, learned counsel for the alleged contemner submits, by placing reliance on the purported affidavit of compliance filed by the alleged contemner, that the construction of the language of the order dated January 30, 2025 was unhappy, for which unconditional apology is tendered by the contemner number 1. However, the intention of the contemner, said contemner, it is argued, was not to flout the order of this court. Since the order of this court was conditional upon sanction being obtained from the municipality, and the present petitioner was making illegal construction, regarding which stop order has been issued by the concerned municipality, the contemner number 1 had no other option but to pass the order dated January 30, 2025 to stop such construction. Next para. Upon hearing, learned counsel for the added contemner number 2 submits that the added contemner had no role to play in any disobedience of the order of this court. Since the present petitioner was flouting the order of this court by making construction beyond the permission of repair granted by this court, that too without any sanction, the application under section 163, BNSS had to be filed. Next para. On a careful consideration of the submissions of parties, we find that benefit of doubt might be given to the added contemner number 2, inasmuch as from the application under section 163 BNSS, we do not find any attempt to prevent our order from being implemented. Rather, it was alleged therein, the contemner number 2 disclosed about the order of this court. Thereafter, the contemner number 2 alleged that without any spot inquiry having been done by the concerned municipality and or any permission being given by the municipality, the present petitioner has been forcibly trying to make a new construction. There were other allegations regarding the present petitioner involving antisocials as well as ancillary allegations. Next para. Thus, the premise of the application under section 163 BNSS was not to interdict the implementation of the order of this court, but merely a complaint that the order of this court was violated by making of construction by the petitioner without any sanction from the municipality. However, next para. However, we cannot extend such benefit of doubt to the contemner number 1. Next para. From the order dated January 30, 2025, it is evident that the contemner number 1, despite being an executive magistrate and a WBCS officer, supposed to be educated above the masses, not directed the EO Rampurhat municipality not to issue, এখান থেকে double inverted করুন, not to issue any permission from his office to the OP on the basis of conditional order of the Honorable Kolkata High Court, double inverted close. Thus, comma, the contemner number 1 not only acted beyond his jurisdiction within the contemplation of section 163 of the BNSS, but willfully and deliberately acted in violation of the order of this court by directing the Rampurhat municipality not to issue any permission from the said office, comma, that too on the basis of the order of this court. Full stop. It is unthinkable that an executive magistrate, comma, with his supposed education, comma, would not understand the purport of the order directing the municipality not to comply with the order of this court by withholding permission to the present petitioner, comma, despite this court having categorically directed the municipality to consider whether such sanction ought to be granted. Full stop. Reiterating our above observations, comma, in paragraph number 8 of the order under contempt, comma, this court had observed that since the repair sought in paragraph 4 small a of the application, comma, the reconstruction of the ground floor roof may tantamount to a reconstruction which requires permission from the local municipality, comma, the said reconstruction is to be permitted, the italic say, subject to sanction in that regard, comma, if necessary in law, being obtained from the local municipality. Full stop. Next para. Furthermore, comma, we had observed in paragraph 10 of the said order that as point number small a, insofar as point number small a in paragraph number 4 is concerned, comma, the appellants bracketed present petitioners bracket closed were permitted to undertake the same, the italic say, subject to sanction being obtained from the concerned municipality, comma, if so required in law. Full stop. Next para. Hence, comma, we categorically permitted the petitioners in the contempt application to make repair stroke reconstruction, comma, only subject to sanction being obtained from the municipality. Full stop. However, comma, by his order dated January 30, 2025, comma, the said direction was sought to be nipped in the bud by throwing a spanner at the wheels of the order in directing specifically that the Rampur municipality shall not issue any permission on the basis of the order of this court. Full stop. Next para. The expression double inverted on the basis of the order of this court double inverted close in the said order, comma, in our opinion, comma, is palpably contumacious. Full stop. Be whatever may, comma, the contender number 1 did not have any authority or jurisdiction, comma, sitting under section 163 BNSS or otherwise, comma, to act in direct contravention of the order of this court and directing the municipality not to issue permission even on the basis of the order of our court. Full stop. Next para. Such act cannot be condoned in any manner whatsoever. Full stop. Next para. We are not so much relying on the latter part of the order whereby the construction was directed to be stopped, comma, keeping in view the allegation of the of the contender number 2 that the construction work was being made by the present petitioner without any sanction from the municipality. Full stop. Next para. However, comma, the restraint order on the municipality was in the teeth of the order of this court and tantamounts to willful violation of the order of this court. Full stop. Next para. Hence, comma, in view of the above observations, comma, we hold the contender number 1 guilty of contempt of the order of this court as indicated above by restraining the concerned municipality from issuing any permission on the basis of the order of this court. Full stop. Next para. Accordingly, CRC number 27 of 2025 is made absolute insofar as contender number 1 is concerned and is discharged with regard to contender number 2. Full stop. The contender number 1 shall is hereby penalized and shall pay an amount of rupees 50,000 to the Calcutta High Court Legal Services. Oh, it is the district. West Bengal State Legal Services Authority within December 24, 2025. Full stop, next para. The legal services, the State Legal Services Authority shall thereafter credit the said amount under the head Victim Compensation Scheme. Full stop, next para. The application, the matter shall next be listed on January 2, 2026 for the purpose of filing of receipt of such payment by the container number 1 before us.
My Lord, may I pray for consideration?
January 9. Let it be January 9. 9 January.
My Lord, may I pray for considering the amount, my Lord?
No.
My Lord, kindly consider, my Lord. My Lord, kindly consider, my Lord. I'm just praying for considering the amount, my Lord. Nothing else, my Lord.
File application for review, my lord, since the appeal itself out of
My Lord, kindly,
matter is pending, my
my Lord, kindly consider the amount, my Lord.
I'm
My Lord, I am praying for just considering the amount.
application for review, my lord, or short prayer.
My Lord, may I pray for considering the amount, my Lord?
Yes.
My lord, kindly grant me leave to file
Dakun
this.
Puta.
Do I appear for the petitioner?
Yes.
This is a affidavit of service.
They were appearing. Mr. Banerjee was appearing. Yes. What is
So far as the alleged contemner number 1 is concerned, my lord, we are filing our affidavit in reply. Pursuant to their opposition. Kindly condones the delay.
We have also been
Kindly condones the delay in filing the reply, my lord.
we have also been served
opposition
with
you are filing today, Mr.
opposition already filed. We have been served with a supplementary affidavit, my lord. We do not know whether it has been filed or not.
My lord,
Did you file a supplementary
I
affidavit?
filed a given advance copy, my lord. I would be relying upon this supplementary affidavit.
You are not relying.
My lord, I am, my lord, relying, my lord, the documents are
You have
already
filed it before us.
my lord, not filed, my lord, subject to your lordship's
We
leave.
have to give an objection if
My lord, because can one, my lord, so far as the supplementary.
If you want to rely, file it. We are granting you leave, but then they have to be given an opportunity to file exception. The affidavit in reply in respect of the contempt application, as well as a supplementary affidavit filed today by the petitioners be kept on record upon granting leave to the petitioners to file such supplementary affidavit. Full stop. On the prayer of learned counsel for the alleged container number 1, the alleged container number 1 is granted leave to file rejoinder to the supplementary affidavit filed today by January 2, 2026. Full stop. The matter shall next be listed on January 9, 2026. No. This bench cannot sit on as and when we please.
The affidavit of service be kept on record.
Affidavit of service shall to be
there is also their application under Order 1, Rule 10. I do not know what purpose that is.
We'll
But
hear
that
My lord, kindly grant me leave, my lord, kindly.
Sorry, we rose late. So
No, 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 no.
oh, no. Yes.
Sorry. No, I'm grateful because I had to rush from my chamber and come here.
It's a blessing in disguise.
But I was reading page 23 of my application.
Yes.
Application ito. What I'm reading. Affidavit in opposition, whatever the scheme.
Yes, yes.
The scheme I am reading right now.
This is application for recall.
Yes, your lordship will find the loss assessment procedure has been provided for under the head post harvest losses.
Yes.
And then when whom to be reported for channel of reporting is given, then my lord, your lordship will read that kindly take this part. Yes. Kindly take page, internal page. No, এটা না, এটা না। আমারটা কোথায় গেল? ও, আমারটা নিচে আছে। Just give me 1 second. I'm so
Yes,
sorry.
yes, yes,
Just give me
yes.
one.
Internal page 21.
Kindly take internal page 21 of this, my lord, scheme. Correct.
Yes.
But what happens in cases of misreporting or etc. That is Roman 18. Insurance company should have received the premium for coverage either from the
Roman
bank.
18.
Roman 18, my lord. 17, I'm sorry. I'm so sorry.
Page, internal page 21.
21 of the scheme.
It's internal page 22, Roman 18.
No, Roman 17. I'm sorry, my lord. Roman
Acha,
7.
acha,
I'm
acha.
sorry.
Yes.
Important conditions or clauses applicable for coverage of risk. My lord has got that.
Got.
Insurance company should have received the premium for coverage either from bank, channel partner, insurance intermediary, or directly. Any loss in transit due to negligence by these agencies or non-remittance of premium by these agencies by the concerned bank or intermediary shall be liable for payment of claims. In case of substantial misreporting by nodal bank or branch in case of compulsory farmers coverage, the concerned bank only shall be liable for such misreporting. But this is the provision made in the scheme which makes it explicit that it would be the responsibility of the bank. Can't you take the next one? Mere sanctioning disbursement of crop loans and submission of proposal of declarations and remittance of premium by farmer or bank without explicit intent to raise the crop does not constitute acceptance of risk by insurance company. This is a case where the accuracy has to be accepted. Now, what is more important, I showed your lordship one reasoned order, which was subject matter of challenge and decided by Justice Sarkar was pleased to hold.
Yes.
That was pleased not to interfere with the order, but pass certain directions for compliance of the directions contained in the order. In another writ petition, which was carried to the Honorable Division Bench, my lord, the Honorable Division Bench, that order, Division Bench order আছে এখানে.
It's not annexed.
It's not annexed, my lord, but it has been referred to in the affidavit of, my lord, the bank. আমাদের affidavit আছে.
No, bank.
Bank. Kindly take, my lord, if your lordship permits me, if I take your lordship, this is MAT 846 of 2022. I will hand off a copy, my lord, of this order. If your lordship, kindly take, my lord. Kindly take your lordship.
আপনি ফাইলটা বার করে দিন, ফাইলটা বার করে দিন।
No,
ফাইলটা বার করে দিন।
it's not there in the file. It's not there in the file because this. এটা কি আমাদের কাছে কপি আছে?
এইটার কপি আছে।
Your lordship will find that the Honorable Division Bench, while deciding an appeal preferred by the farmers,
Yes.
directed the Principal Secretary to take the decision at the end of the order. My lord has got that?
Yes.
Now your lordship may kindly take page 57
এটা ফেরত দিন।
of the recalling application.
Yes, page 57.
57 of the recalling application. This is the second order passed by the department. My lord has got that? Hearing in compliance of the order dated 20th August 2024 passed by the Honorable High Court at Calcutta in respect of MAT 846 of 2022 in the matter of Kollan Poi versus State of West Bengal. The MAT 846 of 2022 was filed before the Honorable High Court by the petitioners, Sri Kollan Poi and 19 other farmers who were aggrieved by the inaction on the part of the National Insurance Company. It was referred to as NICL for not having allowed them the insured sum of money in terms of Angla Shoshyo Bima scheme of the government of West Bengal, hereafter referred to as BSBS, for the Rabi season 2019-2020. The Honorable High Court, by video order dated 20th August 2024, was pleased to dispose of the said application by directing the petitioners to submit a comprehensive representation before the chairman of the state level monitoring committee, that is the Principal Secretary, Agriculture Department, Government of West Bengal, for disposal of the said representation by granting opportunity of hearing to all the parties concerned, including the petitioner, passing a reasoned order in the light of the decision of the Principal Secretary, Agriculture Department dated 9/11/2023 in compliance of the order of the Honorable High Court dated 23 August 2023 in respect of WPA number so and so. Accordingly, following a representation dated 9/9/2024, the petitioner farmers were heard on 21/3/2025 at 12 noon at the Secretariat of the Agriculture Department, Navanno, where 2 farmer petitioners out of 19 total, namely Shri Kullan Poi and Said Nizamuddin, were physically present, while 17 other farmer petitioners recorded their presence online and attended the hearing from the office of the Assistant Director of Agriculture, Kotulpur. Same branch. It's only one branch we are concerned with. The Punjab National Bank Kotulpur branch was physically represented by the branch manager C. So and was presented online by the CRO number CRO2 namely so other senior officers of the Agriculture Department and Director of Agriculture were physically present at the hearing. At the outset, the farmers presented their case and argued that their premium had been duly deducted by the bank in question, and yet they had not received any support of any insurance following the crop damage in the year 2019-2020. The 2 farmer petitioners who were present physically showed their relevant bank statements. The others said they would all present their attested copies of the relevant bank statements at the office of ADA, Kotulpur. The PNB representative said that the bank had remitted to NICL whatever money had been deducted by them towards the farmers' policy, and yet NICL did not extend any insurance support to the farmers. It may be relevant to mention in this connection in this letter dated so and so, that is 29/24/9/2024, the CRO2 of NICL had informed that no farmer details had been uploaded by PNB and hence no farmers from PNB Kotulpur were covered under their insurance for 2019-2020. Asked on this point, PNB representative maintained that they were crippled by a technical glitch as the server had been down for long during the relevant period, as a result of which they could not share the relevant data with the insurer within the stipulated time period. NICL representative maintained that they could not act in absence of any actionable data being shared by the bank in this regard, and in the instance case, no details regarding the identity of the insured farmers nor in respect of each individual farmer's share of premium, etc., had at all been shared by the bank with NICL. Let us now have a look at some of the basic mandates of the BSB scheme for a clearer understanding of the issues involved in the case. In terms of para 7 of the notification dated 29 November 2019, issued by the government of West Bengal for Rabi 2019-2020, a farmer's share of premium was 4.85% of the sum insured. PNB was supposed to deduct farmer's share of premium from the bank account of the farmers in question and send the consolidated amount to the insurance company as well before the cutoff date of 31/12/2019. The bank was supposed to send the consolidated declaration or proposal of loany farmers to NICL for fulfilling the coverage of potato crop within the due cutoff date of 15/1/2020 as per notification of the scheme. That in terms of para 19 of the notification, the bank is also required to upload individual loany farmers data on the PSB portal well before the cutoff date, as mentioned earlier, and also send a consolidated declaration or proposal to the insurance company. This is noted with utmost surprise and anguish that the concerned bank has taken lame excuse of technical glitch on portal, whereas keeping silent as to not complying the scheme guidelines that stipulate submission of consolidated details of loany farmers by the bank to the insurance within the cutoff date for the season. On a query, the bank admitted to the fact that no list of farmers furnished in terms of paras 7 to 19 even within the end of the crop season in March 2020 or thereafter in 2020. Such failure of the bank authorities and in the absence of any proof of enrollment of the farmers in BSB benefits were not found admissible in the instant matters. Be it noted, the same farmers got such benefits in the years when their enrollment formalities were duly completed by the same bank or direct applications to insurance submitting documents and premium. Thereby, it is clear that the scheme is flawless. Lapses on the part of the then branch manager PNB Kotulpur created unusual grievances of the farmers who were all customers of the said bank. In this case, the PNB Kotulpur as well UBI Kotulpur neither uploaded any farmers data in BSB portal nor sent any consolidated declaration proposal within the cutoff date. It is not understandable as to why the bank failed to share the details with the insurer, even otherwise than way of uploading it on the portal if there had been at all been any technical issue at their act in the mandated manner, and thus the entire scheme of the envisaged benefit turned out to be infructuous. The bank authorities hereby advised to settle the issue with the petitioners as per banking norms and extend suitable compensation to the affected farmers. In this context, the branch manager PNB Kotulpur is requested to complete the process of settlement of payment of compensation to the affected farmers petitioners within 2 months from the date of receipt of this order. Let a copy of the resident order be communicated to the zonal head of PNB Kolkata zone or the zone controlling Kotulpur branch for suitable decision to compensate farmers the representation disposed of. But this order, subject to correction by all of my learned friends, perhaps has been challenged by PNB by a fresh writ petition. And that writ petition, again, I will stand corrected, is pending. So, my lord, we have two orders passed by the secretaries, my lord, where, my lord, the secretaries have held, the competent authorities held that it was solely the responsibility of the bank, and bank has to discharge its owners. Bank has to settle the accounts.
This recall application has been filed by you, Mr.
Yes, my lord.
The recall of which order? The order is also.
My lord, the order is of the order.
This is that parent order of which.
Yes, parent order. Your lordship's parent order.
Let us see that order. Page 13 is the ordering portion.
Page 12
Yes.
of the recalling, though.
Yes. Ordering portion, page 13 is just.
My lord, page 12 of the recalling application.
Ordering portion at page 14.
Page 14 is the ordering portion. 13. Since there was no direct fault on the part of the petitioners in non-payment of, may I just read out, my lord? Yes. As such, on such count, the petitioners in both the petitions stand on equal footing, since there was no direct fault on the part of the petitioners in non-payment of insurance premiums, and keeping in view the humble financial position of the agriculturists who are the backbones of the country. It would not only be proper if the insurance company extends the time for depositing the premiums by the bank for a reasonable period. Accordingly, WPA number so and so are disposed of by directing the insurance company to extend the time for depositing the premium by the bank. The respondent bank shall immediately commence paying the due installments of the premiums on behalf of the petitioners under the said scheme to the insurance company. The areas which have fallen due shall be paid at one go by the bank within a fortnight from date. All premiums thereafter shall be paid regularly by the bank, subject to other formalities being complied with by the petitioners. Upon such payments being made, the insurance company shall regularize the insurance policy of the petitioner and honor the same as and when required.
So your ground for recall is that this scheme, that for that year this scheme cannot be revived now.
That cannot be revived now, my lord. The only remedy, my lord, to the best of my understanding, is that, my lord, the loan has to be waived
by the bank.
By the bank.
But they themselves.
That will be adjustment of the accounts, but the bank might very well contend that the second order passed by the secretary, which I just read out.
This loan was taken from this bank only. This.
Yes, Kotulpur.
No, IDBI Bank from the Bisnupur branch. First, Lal Mohammed.
What about IDBI? IDBI also had a similar fault.
There are two branches all over West Bengal, one PNB, one IDBI. The secretary's orders cover PNB, but I have not come across any order passed by the secretary with respect to IDBI. But the secretary's two orders covered the case of PNB. And my lord, I have tried to demonstrate, my lord, one thing very interesting. Now I am getting the clear picture. Two orders were available with the first order was available. The first order passed by the secretary, which I read out before recess. That order was subject matter of challenge in that writ petition disposed of by Justice Sarkar. From perusal of that order, it would appear that the insurance company was National Insurance Company. Because National Insurance Company was heard, their case was considered and order was passed. In spite of that fact, when they filed the writ petition, they implead some fictitious company, namely Agriculture Insurance Company of India.
And this, you have also sought for a recall regarding the IDBI bank?
Yes.
Those orders?
Yes. Yes,
some of the writ petitioners covered the IDBI and some the others.
Only one writ petition.
One writ petition is IDBI, all other.
Ask Lal Mohammed.
Lal Mohammed is IDBI.
May I just clarify few points?
That is item number 10.
Yes,
what is the branch?
And all are IDBI?
IDBI by Bisnupur branch. Same district and Bisnupur branch.
Yes, Mr. Mujumdar, let us hear him first, then we'll come.
Malad, may I just কি বলতে চাইছো বলো? না এখন তো সেটা নয় মানে the IDBI case also, my lord, subject to my lord, whatever my learned friend would submit, my lord, this situation is identical. The bank deducted premiums. The premiums were paid, but the consolidated statement was not uploaded. My lord, আমি তো পিটিশনটা পড়িও নি মানে at this stage my lord না ওখানে কি সেম পয়েন্ট নিয়েছিল ওরা মানে I will not make any same technical glitch point
অন্য ইয়েটা লাল মোহাম্মদ
but the all other petitions my lord apart from this first petition Lal Mohammad or something like that, the petitioner's name is Lal Mohammad, Sheikh Lal Mohammad, that petition the bank would be IDBI. All other petitions,
but you are moving that also.
I'm moving that also. I'm moving that also.
So what are the facts of that case? We have to just check up. But there was no order of the secretary or something like that. Bank admitted anywhere that it was their technical glitch or something.
Yes.
Where do I get it?
Malad, I have not seen Malad. I should not be making any statement without going through the Malad content. PNB I have seen. That is why PNB I am submitting.
They have filed a recall in that also.
I filed a recall, but Malad, I understand.
Somebody has to move it then.
Somebody has to move it. IDBI te ki case ache? Amar petition ta dekhao.
Order was identical.
Opposition ta kothay? IDBI te amader against it. তাহলেই তো বোঝা যাবে where is their opposition in IDBI? Oh, they have not filed in opposition regarding them. But so my lord, we don't know, my lord, we don't know really, my lord, what is the reason for
not also in my order it's recorded that they stopped due to technical glitches.
My lord, might be, my lord, but my lord, I should not be making any comment, my lord. It will be inappropriate on my part.
So then we are not hearing you on that.
My lord, your lordship would be hearing me.
It was not uploaded.
My lord, it was not uploaded, that is for sure. That fact is identical. Rest of the fact, my lord, the orders of the secretary passed by the secretaries are not available in the case of IDBI. But my lord, the application has been filed. Application has been filed for recalling on the basis, my lord, that the consolidation statement was never uploaded.
Logic is the same.
Logic is the same. But these are my respectful submissions.
Let us hear the banks one by one. Ms. Oja will come to you first. Let us hear the PNB, then we'll come to the IDBI.
Lordship, first, your Lordship, I'll be drawing your Lordship's attention to your Lordship's order, my lord. Well, in my affidavit in opposition, my lord, to the contempt application, your Lordship would find that order. Well, all the orders passed by your Lordships are there. From page number 18, my lord, it will start.
This is in
my affidavit in opposition.
Shubham Mohapatra.
Yes, your Lordship. Shubham Mohapatra, CPN 1996.
Opposition, yes.
Affidavit in opposition to the my lord, contempt application.
Yes, but
from page number 18 onwards, my lord.
Page 14 onwards, orders start.
14 is the order passed by Her Ladyship, my lord, Justice Shampa Sarkar. Your Lordship's order, my lord, is starting from page number 18.
All right.
Lordship, there has been total 10 writ petitions and your Lordship has passed the same order. My lord, we have communicated this order to the insurance company by email dated 13th of August 2024. Your Lordship will find which is at page number 13.
Ms. Rachudi, we are also hearing this the
recalling.
Recall.
Lordship,
first we have to discuss
yes,
the recall.
Lordship, why I was telling Lordship, I'll come to the recalling first. My lord, the recalling there is first. My lord, my humble submission, it is not maintainable for the very reason, my lord, the order was passed on merits. Why I was drawing your Lordship's attention to your Lordship's order, because your Lordship first records that affidavit of service was filed in court and despite service, my lord, the insurance company did not appear. The insurance company in their recalling application has stated that they were not aware of the order before February 2025. Once the contempt application was filed, they were aware of this order. That is why, my lord, I was drawing your Lordship's attention to the email that all these orders, along with the list of the farmers, were communicated to the NICL by email dated 13th of August 2024. Second of all, your Lordships, regarding the bank's liability, that whether the bank is solely liable or not. Well, first of all, the bank's endeavor is to, my lord, that the farmers must get their shares, and the bank is the only one, my lord, approaching before different courts, saying that only because of technical glitches we couldn't upload the datas, kindly extend the time. We needed a slight cooperation from the insurance company, and your lordship's order was also that may the time be extended. Well, nowhere in any forum your lordship's order has been challenged. They were aware of your lordship's order. Your lordship's order was passed in the month of November 2023, your lordship. After that, the principal secretary has passed the order. Thereafter, another order was passed. In none of the orders, there is a reflection of your lordship's order that yes, the time could be extended. The insurance company kept on saying that it is the fault of the bank, hence the bank will be liable to pay the compensation. But the strength of your lordship's order, my lord, was never seen by the insurance company or by the, my lord, by the state authority while disposing of this.
Why shouldn't the order be revisited, Ms. Roy Choudhury? Because
My
it's clear that it's the bank's liability
Uh,
under the scheme
my
to
lord,
upload these details.
My lord, in that regard, I'll be placing the scheme once, my lord. This portion of the scheme was also not shown. Lordship will kindly come, my lord, at page number.
Let us internal page you can refer.
Yes,
We are looking at their
internal page 10, page number 26 of their recalling application.
Yes.
Lordship, clause 13, point number 13, last 3 lines, it says that the concerned insurance company within 15 days after the cutoff date for submission of the proposal or declaration to the insurance company, and also upload the same on the insurance portal. It is liability of the bank to upload it within the cutoff date. If not, 15 days extension, my lord, will be provided. Now your lordship will kindly come to clause 14, which says that insurance company may also collect the requisite information in respect of non-loany farmers from the channel partner in the same format.
These are loany partners. These are not normal.
Lordship, I knew this would come up. That is why, my lord, will see. It is the responsibility of the concerned insurance company to collect and obtain the details of the insurance farmers, both loany and non-loany, from the bank or financial institution and intermediaries agent. Well, my humble submission in this regard. Now, if your lordship kindly takes the order which was passed by the principal secretary at page number 52, your lordship will find that within the cutoff date, the bank has paid the premium. Premium, my lord, was paid at 31/12/2019, which is not disputed by the insurance company, not disputed by anyone, your lordship. The only thing, the bank couldn't upload the data because of the technical glitches. That has been said, well, not from now, but from the very inception. The bank is saying that there was technical glitches for a long period of time. And Malor, I'll be showing that technical glitches happened all over the nation, not only because of not only for PNB, but also for other banks, Malor, Bank of Baroda, and cases from there in this regard, Malor, has went to the NCDRF and Malor everywhere, that the farmers are not getting the crop insurance for this particular period. So there was a technical glitch. I'll be, since Malad, it's a high court, I will not be placing the order passed by the National Consumer Dispute Resolution Commission, your lordship. I'll just...
What order was passed?
Order was passed that a liability goes to all, not only to the bank. Every time the bank cannot be victimized for the fact that yes, you have not given within the cutoff date, you are victimized. Malad, bank is trying heart and soul so that Malad, the farmers get the benefits. It's only the bank, your lordship will find in every order that it is only the bank, Malad, the bank is running from pillar to post, so that Malad, a cutoff it could be extended. There could be a means by which...
How do you deal with page 37? Please come to page 37. Lordship. Roman 17, clause 2.
Lordship. Malad, there was no misreporting by the bank. It is not that the details of the farmer were misreported to them. The details of the farmer were not uploaded. There was no misreporting. There was nothing. Malad, the scheme also says that insurance company has a pivotal role in that. Malad, also, Malad, they have enjoyed the premium from 2019. They had repaid it back, Malad, in the year of 2023. For 2 years, they had the premium with themselves without questioning why was the premium there. Malad, no, there was a dispute resolution clause in this particular agreement as well, that if any dispute occurs, it will go to the Department of Agriculture. They never, Malad, have raised any question to that, nor the dispute was ever given to the, nor the dispute was ever tried to be resolved by giving an application before the...
But if you read 2 along with 3...
Lordship, mere sanction or disbursement of crop loans, does not constitute.
And submissions of proposals, declarations, and remittance without explicit intent to raise the crop does not. Anyway, so that may not be so important, but substantial misreporting, why shouldn't you cover? Because non-reporting also comes within misreporting.
Non-reporting, yes, my lord, I bow down that there was a non-reporting, but my lord, the reason for non-reporting has also to be seen.
But you could have manually reported as rightly held by the principal.
My lord, there is no clause in that where we can give the details of the farmer. My lord, we were waiting that the period would extend, because there has been instances where the periods have been extended by the insurance company, and my lord, the premiums were given. My lord, and the petition was filed in the year of 2023, when after hearing the parties, my lord, your lordship was pleased to pass an order that yes, the may the time period for the extension of the time period be extended for.
But the difficulty is because today we are in 2025. How can a scheme of 2019, 2020 be revived?
But there has to be some
someone has to bear the burden.
But someone has to bear. But why, my lord, only the bank? My lord, this question I put to myself, because it was not the case that bank was at fault. The insurance company knew about this order passed from the year of 2024. My lord, they were sitting tight over it. They
What
did
order
not.
passed?
My lord, your lordship's order. My lord, we have communicated this order, my lord. They were aware of this order. They were aware of everything, your lordship. But they never challenged the order. They never felt to come up before the court with a recalling application stating that these are the circumstances. Well, when the recalling was filed, when the contempt was moved, when your lordship was of the view, why the insurance premium would.
See, the order is unworkable in the sense that I had directed them to extend the window,
lordship,
which is apparently not workable because we are
lordship,
in 2025 now.
Lordship.
A 2019-2020 scheme
Lordship.
cannot be revived in that sense. So if the order is unworkable, court can always recall that order and consider passing a fresh order. The court itself can do that also. It has been brought to the notice of the court that that is unworkable. So which is apparently correct. Now, question arises as to who the liability should be cast on.
Yes, lordship.
Because these provisions are very clear. Because the principal secretary order is actually very, well reasoned, in the sense that we are not saying that we are bound by that. Obviously, we are not. But even then, Justice Shortcut's order said that they were to consider the undertake this exercise they have taken. So it was pursuant to an order of court. Justice Boschak's division bench also said so. So pursuant to that, an order has a decision has been taken by them, which seems to be very plausible. Why shouldn't you be held guilty for this? It was you whose technical glitch led to all this entire
Whose
problem.
technical glitch, and the technical glitch is a.
So you could have always informed them that there's a technical glitch at the contemporaneously. There was no effort on your part to inform them that these are the whatever you had to upload. You could just inform them. If you could show something that you tried to inform them, still they did not work on that, then we can understand. Now, the moment you seek an extension, that's subject to their discretion. They may or may not extend.
Lordship, only one humble submission in this regard. Malad, the insurance company was also holding our money for 2 years. They also, Malad, did not raise the question as to why the money has been.
Refunded the money to you.
Malad, after 2 years, your lordship, that is there in my affidavit in opposition. Malad, after 2 years, the dates are also given. If your lordship kindly comes to Malad, page number 57.
That was pursuant to some order of any authority or court that refunded.
Principal secretary's order.
The principal secretary's order.
No, prior to that, Malad, they returned. They returned on 21/11/2023. The principal secretary's order, my lord, was in the month of December. So prior to.
There are two orders of the principal secretary.
The first order of the principal secretary was dated 9th of November. Pursuant to the directions issued by the principal secretary on 9th of November, on 21st November 2020.
I stand corrected, your lordship. But for 2 years, they were also holding the money. They knew a sum of rupees more than 12 lakhs and odd, my lord, was deposited by the bank to the insurance company. The insurance company never raised a question. The bank was under an apprehension. Yes, the time, since they have taken the money, the time period would be extended. And my lord, the technical glitch, my lord, I once again submitted.
Really crediting the money would not fulfill your liabilities under this scheme.
No, my lord, I bow down that my liabilities.
Because some money amount may be credited to the insurance company. They wouldn't be knowing the details, the particulars. How would they credit that to the farmer's insurance account?
Even if, my lord, not there, even when the communications were made, my lord,
that they has to comply with this order. Well, they never raised a
manually
question.
send them these copies.
There was no
Particulars could be sent.
There is no provision in this scheme also, whereas my lord, there is provision that yes,
The provision in the scheme is very clear. You have to do it within a limited period.
yes. And also, my lord, the scheme also says that the insurance company may collect the requisite information in respect to non-loanee as well as, my lord, loanee farmers from the bank, my lord. It is there at page number 26. Both loanee and non-loanee. It is there in brackets, my lord.
Clause 14.
Yes. No, they also had a duty.
That is, me also collect requisite information in respect of non-loanee. It is responsibility of the concerned insurance company to collect, obtain details of the insured farmers from the bank. That is there.
Yeah, my lord, both loanee and non-loanee is there, my lord. They all.
Yes, within bracket.
Yes.
But the caption is non-loanee.
Caption is not loanee, but my lord, here is specific.
It's just a sentence. I mean,
that both loanee and non-loanee. My lord,
loanees are covered. Loanees are covered by a different clause where there is no such responsibility cast on them. Because loanee is covered in clause 10, Roman 10 from 3 onwards. Loanee farmers compulsory coverage. Under that heading, we don't find any such responsibility. Non-loanee farmers is optional coverage. Regarding that, this has been incorporated in that, under that. And this is non-loanee farmers optional coverage directly to insurance companies. This says non-loanee farmer may submit insurance proposals personally to insurance company with requisite premium. In those cases, this will be the modality. But this is not such a case. The farmers went through you.
Yes, they were the loanee farmers, your lordship.
So this is not a case of non-loanee farm. Please come to page 25 of their recall.
Lordship.
The last caption, non-loanee farmers optional coverage directly to insurance
companies.
Only under this head, this liability comes. Which is
Only, my lord. Kindly see page 18, my lord.
18.
18. The scheme's introduction. Internal page 2 of the scheme. Internal page 2, my lord. Roman 2, numerical 3. Roman 2. The scheme would be optional for non-loanee farmers.
No, that is different. Yes.
Optional. It is optional for non-loanee farmers. This scheme is optional for them.
No, but once they choose to have the coverage, then it becomes, they make a choice.
Separate condition.
But that is not important. Obviously, non-loanee and loanee are different
Only
categories.
the major difficulty is that unless and until the consolidation statement is provided, there is no proposal for policy of insurance. That's the main issue.
But I humbly submit today, your lordship, that
No,
whether
that clause probably, Ms. Roychaudhary, is not applicable because here, page 25, non-loanee farmers optional coverage through channel partners is completely different.
my lord, in that case, my
And
lord,
compulsory coverage is also there.
lordship, in that case, my lord, both loanee and non-loanee, what is written there, my lord, that then this has to be interpreted whether this has been correctly stated here or not. My lord, assuming it to be true, my lord, the insurance company has a role. My lord, today what I'm submitting before your lordship, my lord, admittedly, there has been a fault on the part of the bank. But my lord,
No, Ms. Roychaudhary, it's very clear. The one which you are relying on covers non-loanee farmers or very non-loanee.
lordship.
But this is a stray addition. I mean, both loanee and non-loanee, we have to read this as optional for the, I mean, it's a discretion of the insurance company. This cannot be a liability of the insurance
My
company.
lord, today the question
Because there is a specific, there are other clauses which cover this category.
I bow down. My lord, today that the question which I put to myself is that my lord, whether the principal secretary can also come forward and say ki now the bank
Let's
is
forget the principal secretary for the time being. Now, these clauses are very clear. Page 24, loanee farmers, compulsory coverage. This, whenever banks sanction loan for a notified crop, then it starts. And clause 5 says bank branches of commercial branches, etc. under its jurisdiction shall consolidate insurance proposal statements from their bank branch, respectively, and forward the same to the insurance company along with the details of remittance, RTG. Did you do that? You did not.
but details of
That is the
remittance were
proposal
there,
itself.
and details of remittance was there. My lord, bank could partly comply with it. My lord, what was there?
5 says you have to forward the same. Consolidate and forward the same to insurance company. Consolidate what? Proposal stroke statements. Consolidate, forward the same along with details of remittance stroke RTGS towards insurance premium in accordance with cutoff dates as specified by the statement. So therefore, you have to categorically not only forward the proposal, but also these particulars. Otherwise, this does not take effect at all for the insurance company.
I bow down for that.
Their
Your Lordship.
liability does not arise at all.
I say today that the bank has partly complied with its liability, had paid the premium. That is not all, my lord. What the bank needed to do is to give a consolidated.
Part compliance does not give
My
rise to a liability on the part of the insurance company.
I bow down, my lord. What I'm submitting today is, your lordship.
Then you have to waive your loan on that. It's you who had given the loan, so you have to waive your loan for that particular period, subject to the coverage of this. The coverage amount, you have to waive your loans because it was your fault. You are not to pay any money now, but you have to waive your loans. Yes. We will direct that. Because it's your liability that you did not upload
The
these things.
petitioner would be able to say, I believe, that what is the status of their loan account now.
So that
I mean,
you
what
can check from your accounts also. You have the list.
Well, I can come
They
back.
paid the premiums, you deducted the it is you who deducted the premium.
Yes.
So you must have the particulars, you know the loan coverage also.
Malad, let me come back regarding this. Malad, if this
No.
would be done,
Whatever is the coverage in case of each of these individuals, you will have to pay the waive the loan to that extent for 1920.
Whatever is the coverage, Malad.
Whatever is the coverage for each individual, subject to being satisfied of the coverage.
Lordship.
Because you have the details, particulars.
Malad, but whether the loss has been suffered or not, Malad, that had to be assessed. The bank will not be able to assess that. And there lies a difficulty. Malad, and today the entire problem is, Malad, the entire gamut of the problem is that
The bank has its agents to, undertake queries regarding when they give loans to people. They have their agents to assess the loan risks and all these things.
Question of the loss assessment, it is completely duty of the state
Suppose
government.
it is not under the scheme, you give a loan independently. Now, don't you have any mechanism to ascertain whether that loan has been defaulted? Because you declared accounts NPA, you have a discretion not to do that also. So you must have some assessment mechanism in place, which
Well, that is as per the banking norms, Malad, whether 3 months of default.
they'll have to satisfy your officers as to whether the loss has been suffered or not.
Well, a loss has been suffered or not, that is upon the state government, well, to assess and report the
So
loss has been suffered. We just get a data from the farmers.
We can direct the insurance company to provide their investigator for that if necessary.
Lordship.
But you will have to pay for that also, their service charges.
Well, at this and I
If you don't have the whereabouts.
Whether, well, there must be some
You can
mechanism.
engage independent professionals to do that, but at your cost, to assess whether they have actually suffered any loss. You can appoint your professionals. You can even loan them from the insurance company. We have no objection, but that will be at your cost.
Well, may we have that data from the petitioner? What is the loss suffered?
They have to satisfy you in the first place.
According to them, well, let them satisfy us. And if this goes, your lordship, then
what do you say to that? Because you have to show them in the first place that you have suffered a loss. Whatever mechanism is available for the insurance company, same applies here also.
And then the writ petition, if the lordship kindly see me, Lord.
No, not writ petition. It is not a question of writ petition. You have to independently satisfy the bank, at least provide materials to the bank to show that you have suffered a loss in the first place.
No, actually,
You have to just show that you had taken so much of loan and that for that season you had suffered the loss.
That I have stated in my writ petition, I made the representation below. This such loan I have taken up and my crops are damaged. Kindly pay me the as per insurance claim. Kindly pay me the
damage. You have to substantiate also. Even if it was the insurance company, you have to. Mr. Mujumdar, do you have any instruction on that? Can you take instruction? What is your mechanism for assessing the loss?
May I help?
To be contemporaneous.
No, may I help? In the scheme itself is provided.
State can obviously.
No, in the scheme itself is provided.
Which was that?
May I respectfully invite your lordship to internal page 15 of this scan, Milord, recalling application. Kindly sees, Milord. Internal page 15, Milord. Roman, Milord. 14, Milord.
Yes.
Kindly sees, Milord. Clause C, Milord. Loss assessment procedure. Time and method of reporting of loss. Immediate intimation within 48 hours by the insured farmer to any one of the detailed below. Next page, Milord. May I take your lordship to? Intimation must contain details of survey number wise insured crop and acreage affected, premium payment verification, whether applicable, to be reported in next 48 hours by the farmer / bank. Whom to be reported? Channel of reporting. Intimation may be given within 48 hours by farmer, either directly to the insurance company, concerned bank, local agricultural department government, district officials, or through toll-free number to the insurance company. First mode of intimation will be centralized toll-free number. In absence of such a facility, the report can be given to banks or government officials, and the same would be forwarded intimated to the insurance company immediately. The banks should verify the insured details like crop insured, sum insured, premium debited, and date of debit force. Documentary evidence required for claim assessment. These are documents. Now, appointment of loss assessors by the insurance company. Loss assessors would be appointed by the insurance company for assessment of losses due to the operation of post-harvest losses, yield insurance. Loss assessor appointed should possess following so and so. So, loss assessor is provided for in the this
that is provided by the insurance company as per this.
So, they will have to
banks should verify
an
the
intimation
insurance
to be
details.
given either by the farmer or by the bank. This 48 hours, this.
But may I suggest a way forward, subject to a lordship's kind consideration? Keeping in view the interest of the farmers, what can be done? This is 2019-2020 Rabi, which is perhaps during this time only. This is the winter crop, as we say. My lord, what can be done? The district administration will be able to point out, with the help of the Met department, will be able to point out whether what kind of loss would have been sustained by the farmers during that relevant point of time. Because this is not so far off. This is not 4-year, 5-year
historic.
It's prehistoric thing. So, whatever data must be available, your lordship may kindly recollect. This is the data just preceding the onset of the pandemic. So, my lord, data must be there. At least the Met department would be able to supply the data. The Met department will be able to point out whether there was torrential drain.
Do that under the aegis of the district magistrate also.
District magistrate administration has to undertake with the help of my lord. If it's a block, so it has to be block land and land reforms officer, and also my lord SDO.
You can keep it, put it to the discretion of the district magistrate also.
Yes.
Take a report.
May I just suggest? This is I never considered this as adversarial because there are constraints on me. May I just suggest? The principal secretary has taken a decision. The principal secretary is of the view that must have been loss. But if it has to be assessed and if it has to be ascertained at all whether there was any loss, case-to-case basis, then district magistrates are to be involved, and also, my lord, with the help of
where does the district magistrate
there is
get
one
the
more
loss
aspect.
assessors?
There was one more aspect with a department which can help, the Department of Disaster Management.
Disaster management can only give broad data.
Broad data for the purpose of
But the extent of loss.
No, we were
Who is
thinking
going?
in the line that
district administration can definitely do.
No, your loan assessors can also be
Lordship.
the remuneration can be paid by the bank. We are looking at that. Not
Malad, I can do. Whatever direction your lordship would pass,
they can borrow your loan assessors.
they can.
For this
We appoint loan assessors. Loan assessors are
There's
not
a panel sort of thing or something.
Panel. It's a panel. We can provide the panel to the bank. That the bank can appoint the loan assessors from that panel. Yes, my district level authority.
We are not done with hearing you.
No.
Just
district level authority.
And Ms. Oja has not yet been heard at all. So no difficulty on that.
A district level authority to invoke provisions on account payment due to mid-season adversity. Kindly take this data.
Has the petitioners applied within 48 hours?
That is what the thing is, my lord.
Then you are not eligible at all. This entire exercise is futile.
They are illiterate person, they do not know what.
That is an excuse for anything because the scheme specifically. When you take advantage of the scheme, you have to abide by the scheme also.
Lordship.
The fact that they are from their crops were damaged. That's why they came before they made represent to the bank authority.
When did you make the representation to the bank? How long after?
2023.
2 years after.
2023.
Senior is telling regarding Met office can give that yes, whether during that
That's
period
the broad thing.
there was any storm or any national
Can I
calamity.
just
But
indicate
extent of damage of
in
the
the
respective
government
farmers.
in the government notification, for this Bisho ki Bangla
Bangla Shosho Bima.
Bangla Shosho Bima.
Bangla is not.
There is a grievance
Bisho is
redressal
not there.
mechanism.
Bisho is not.
The Bisho is not there. Shosho is there.
Bangla Shosho Bima. Yes.
Well, Shosho is there. Your lordship will find there is a district level monitoring committee and there is a block level monitoring committee. So the district level, block level monitoring committee must be having some reports regarding the adversities faced by the farmers.
Mr. Gali, we will request you to take instruction on this. Regarding
And
this,
so far as the loan assessor is concerned,
what
my
can be the
lordship,
modality we want to involve the district magistrate, because otherwise there will be no sanctity to the process. Anybody and everybody cannot do it. We have to have some sanctity to the process.
No,
District
absolutely,
magistrate is a
well, after all, madam, we have to keep in mind, well, after all, this is again flow from the state exchequer.
Yes, we'll give them some time definitely, ultimately, because it was your scheme originally. So you have to have a hand there. We'll decide the liabilities after completing hearing of Ms. Roy Choudhury and Ms. Oja. And after that, if you fix the liability on whoever, either the insurance company or the bank, whoever ultimately we fix the liability on, if it's the insurance company, their loan assessors do it. If we hold against the bank, then your mechanism has to be involved.
So far as our this,
as Mr. Mujumdar suggested, this district level monitoring committee and all, whether they can do the job. You take instruction on this, we'll come back next Friday. You have a bench at 3.
Actually, block level monitoring committee is there.
You take instruction on that. Conclude.
No, whether there was any complaint at that point of time.
Even now, if there is a complaint, whether the block level reporting committee, they can do it.
This is a 5-year-old record.
We have again, Malad, send this amount, send the premium amount, Malad, by way of demand drafts, Malad, which is at present lying with the insurance.
No, we have brought
No, hey,
We'll again direct them to return.
Yes, we are carrying
that
the
is there.
draft.
That is there.
We'll do
Lordship.
Your lordship,
No, your lordship directed to keep that with them.
We don't want that share of premium.
Heard in part for further hearing on 19 December 19, 2025. Come with some suggestion, Mr. Gali.
In the context of loan, this damage assessment, who can
damage assessment? Yes.
Who can do it?
Yes. Your under the scheme, please check up whether there are
monitoring agencies there.
So whether they can do this.
Well, I am told that your lordship has posted some matters on 19th in the original site, subject to correction, my lord.
Original site I take up in the morning.
No, the list indicates that after the original site is over or 3:30, whichever is earlier.
Yes.
And 3:30 never happens on Fridays, thanks to us.
No, I continue. If people are available, then I take up matter. Even state is
why
represented
deprive us of that, my lord? Well,
because if both parties want to do the matter, why should we shirk our duty? It's my job to. I am paid for
carry space, man.
No, state does it. State cooperates. I am telling you, Mr. Mujum, not only Mr. Gali, Mr. Shengupta, Mr. Gali, many people. So many people and litigants are there. I mean, you know the situation.
I know.
I don't force people. I cannot force people. If you don't want to do your matter, what can I do? At best, I can dismiss for
default. Will your lordship fix it at 2 p.m. subject to your lordship's pressure? Subject.
Fixing at any particular point of time is difficult, Mr. Mujumdar. If somebody
If
is
the
in
list
difficulty,
collapses, then obviously this will be taken up.
if somebody is in difficulty, this is now it's a joint exercise sort of thing.
Yes.
So let us come back on Friday and if
very well.
The insurance company can also come back with instruction, because there are a case of non-loany farmers as well, that whether any loss has suffered by them at that point of time.
That has nothing to do with this.
No, non-loany farmers.
No, ওই time এ Rabi crop.
May I pray for online order?
You are saying for the data.
For the determination of that, your lordship.
If take instruction whether you have any database on that.
May I pray for online order, lordship?
Because the other districts and other places must have made.
But I tell your lordship, so far as PNB is concerned, it is only this branch.
No, not that. Not the PNB thing.
Non-loany.
You must have paid off insurance. I mean, covered insurance for other farmers in the neighboring areas. Regarding the data.
That means in and around Kotulpur.
In and around Kotulpur. So you would be in a position to
that
get that data.
Then, my lord, kindly give us some time.
No, you take instruction whether you can do that. It may be available right now.
Well, we can get that. If we have, we will get it. If we have, we will get it.
Lord, may I pray for a line in the order sheet, lordship?
No. What sort of? Tell us.
Instruction in the context of
and that is
learned counsel appearing for the insurance company as well as the state are requested to explore the modalities of assessment of the damages to crops, if suffered during the 2019-2020 period in the Kotulpur by the farmers in the Kotulpur area. In the meantime,
lordship.
Much obliged.
Definitely. আপনি একবার ক্লোজ করে দেবো আজ করে তুমি নিয়ে পড়ে বাড়িতে দিয়ে দেবে
Lordship, I would like to mention, Lordship, because Mr. Karmakar, who is representing the administration, his grandmother has expired today.
Grandmother might have expired. We are very sorry for that. Our condolences, but we cannot urgent the matter. We cannot reassemble time and again for this. Sorry.
Mr. Karmakar has submitted.
Yes, yes. He has
We
submitted.
have to hear the
Lordship.
Shatadru.
You are appearing the matter? We'll appoint him and make a skill.
My lord, Mr. Chatterjee will appear, my lord, virtually, my lord.
All right, let him appear.
No difficulty, let him appear.
No, let us first see the records, whether the FA3 2022 records have arrived from Andaman. এসছে? ঠিক আছে।
The only thing I need to inform your lordship is, my lord, we were unable to serve on the, my lord, Mr. Shatarup Banerjee's client because we were not in a position to, my lord, get hold of the address.
রবিন বাগচি না?
Yes, it's the other matter.
রবীন বাগচি।
রবিন বাগচি তো?
এটা তো আন্দামান প্লান্টেশন, সুতরাং ওটা রবীন বাগচি হবে। এই তো
এবার রবিন বাগচির অ্যাড্রেস তো আমরা পেয়েছি, একটু রেজিস্টার। আচ্ছা,
শোনো না, বলছি এটা তো রেফারেন্স, কে আসবে আসবে জোর করে
তো এখন পর্যন্ত জানি না রেফারেন্সটা।
রবীন বাগচি পয়সাই দেবে না।
না দিক, কিন্তু তাহলে একটা নোটিশ করিয়ে দিই। হ্যাঁ,
রবীন বাগচি তো ওই ম্যাটারটায় পার্টি ছিল, কিন্তু এটা তো ইস্যুটা রেফার হয়েছে ল পয়েন্টে।
Rubin is successful for Rajoshi. All probability that will not be sustained.
Lord, in FA3, I will be appearing for the petitioner, my lord.
Who? You are?
My lord.
You are for Robin Bagchi?
Robin Bagchi, yes, my lord.
I am for the respondent, Dr. Joy.
Oh.
Very good, very good.
Okay, then you
Solves every problem.
Yes, what is your...
We only have to hear you, sir.
No, and Mr. Chatterjee.
Mr. Chatterjee তো বলছে আর কিছু বলবোই না।
That's very good. Then
Mr. Chatterjee, my lord, agrees with Mr. Shatadru Chakraborty's argument.
Okay, okay, Shatadru, just sit. You help us as an amicus. Yes, then.
Yes,
Mr. Bakchi's client,
yes,
learned advocate.
Mr. Kumar, you start.
Kumar,
Yes, my lord, here, my lord, the appellant relied on the Calcutta High Court Extension of Jurisdiction Act 1963.
1 second. Boyfriend? Huh? Jinu? Boyfriend? Jinu boyfriend? Yes, sorry, please.
My lord, here, my lord, the appellant relied on the Calcutta High Court Extension of Jurisdiction Act 1953.
আমাদেরকে সরাই, তোকে
লিখতে হবে, একটু পেন দেবে গো।
তোকে দেখতে পাচ্ছেন, তোর এক্সপ্রেশন গুলো দেখাটা খুব ইম্পর্টেন্ট।
Can you see all of us? Are we all visible to you, all of us, all three of us?
Yes, my lord.
Okay.
No, my lord, Justice Bharadwaj is not visible to us.
That was our... His expressions are very important in this matter.
That's exactly why I pointed out that Justice Bharadwaj is not visible to us.
একটু ঘুরিয়ে দাও, জাস্টিস ভরদ্বাজকে দেখতে পাচ্ছেন না।
কোনটা, কোন লোকটা?
না না, জামাই পড়েছে, ওর কালারটা ডিসকালার হয়ে গেছে।
ওটা ক্যামেরার আলোর জন্য। আসিফ,
Where is he anyway?
some posh 5-star.
Where are you, Mr. Chatterjee?
My lord, I am home, my lord, in my poor little
All right. God bless your poverty. Yes, sir, please.
My lord, may I proceed, my lord?
Bharadwaj pointed out something, I don't know, my lord, what it was, but...
Yes, yes.
My lord, so there is no doubt that this Calcutta High Court has jurisdiction over Andaman Nicobar Islands, no dispute at all. I am also agreeing with that. But the only issue is that in the Andaman Nicobar Islands, there is a civil code 1940 is there. Civil Codes Regulation 1940, which was promulgated by the General in the year 1940. Governor General in the 1940.
Lieutenant General.
No, Governor General.
Yes, sir.
Governor General prior to independence.
But you obtained an order before the Justice Bharadwaj's bench that Andaman courts have that Kolkata courts have jurisdiction.
High Court has got jurisdiction.
High
Appellate
Court has the
jurisdiction.
jurisdiction.
No
High
doubt
Court
about
has
that.
yes.
No doubt about that. But
No,
my point is
unlimited
that
jurisdiction. If there is unlimited jurisdiction of the district court, then High Court
yes,
does not have jurisdiction. So that you got that point approved before Justice Bharadwaj. Although without citing these 1940.
no, I cited this regulation. I cited this regulation before Justice Bharadwaj. I cited this.
So you
No,
are
the question is that are you supporting the stand of the union now?
My point is that, my lord, I am supporting the regulation, Andaman Civil Court regulation. We are governed by
That the district judge will have unlimited jurisdiction.
yes.
Then
That
there
is
is
my
no point in submitting anymore. All
Then,
of us are
then
tied
you
on.
are all agreeing to this.
yes.
তাহলে আর কি আছে? We can just reference and answer করতে হবে as in terms of Justice Bhattacharya's order then.
Yes. You are supporting it.
If it's just that Justice Bharadwaj needs to, my lord,
Yes.
also, my lord, be satisfied that that is what the law is. That's
So
that's
we
the
have to
only-
decide it. We have to decide it. Reference
Malo.
has to be decided.
We'll
Malo.
decide it.
We'll record
But
that.
as of today, all the learned advocates
So
are
if-
item
if-
on one thing.
Yes, my lord. If Justice Bharadwaj is satisfied, my lord, I don't think we need to, my lord, proceed at all.
Reference has to be answered, Mr. Chatterjee.
Yes, my lord. So if Justice Bharadwaj has any question vis-a-vis his judgment, my lord, we must satisfy his lordships as well.
সামনে তো অ্যাপেলেট রুল ছাড়া কিছু প্লেসই হয়নি।
হ্যাঁ।
না না ওগুলো আন্দামানের ওগুলো হয়নি।
Nothing was placed. If it was placed, your judgment would be the same.
Mr. Chakraborty, you have those regulations?
Lord, it's all given to your lordship, Lord, in a bunch.
আচ্ছা, yes. না
আছে গো।
না
No, my lord, we'll get it in our matter, my lord.
25
84 of
Fourth of
2020.
hearing before your lordship, my lord, we had submitted.
Then that file should contain.
Yes, my lord.
That file has everything there. In a bunch, it was given to your lordship.
F84.
We are not sure of how much they have transmitted to us. That's why we are a little. একটু দেখে নিন না আছে কিনা তাহলেই তো
Do you remember?
Yes, if I see it, that was heard here only, my lord. So it should.
এটা
that was
My
heard
lord
here?
was sitting here.
No, heard here but transferred later.
আমি virtually হয়েছিলাম।
এখানেই hearing হয়েছে।
কাগজগুলো তো এখানে ছিল।
সিএবি
না এটা তো এটা কম্পাইলেশন।
কম্পাইলেশন আছে নেই আমি তো জানি পাঠাবে না।
না না পাঠাবে না কলকাতাতেই ছিল তো এটা ফাইল মেইন ফাইলটা এফএটির মেইন ফাইলটা কোথায়
ওখানে
ও ইয়েস
The file has later gone before the district judge.
ফাইল has got to Andaman
এটাই বললাম, it
ওরা
later went
পাঠায়নি
to
কোনো
Andaman.
ফাইল আর?
ওটা এখন তো matter was sent to the district judge, my lord. That appeal was sent to the district judge. Now that has also been disposed of.
কুমার সুধীর কুমার
ওর তো টাইম হয়ে গেছে রিটায়ার করার।
ঠিক আছে কিন্তু ওকে বোঝাতে হবে যে
He's disposed of the matter, my lord. We have
On
been
the merits,
successful.
now it is in civil revision before the
বে অফ বেঙ্গলে চলে গেছে
But then we can give it to your lordship here, my lord. We have it here.
Give us a bunch.
Yes, my lord, we will
Give it.
whatever was referred to in the
আমি
other order, my order, just those documents are required.
No, I have it in a bunch with me. I can give it to
Mr.
your lordship.
Chatterjee, please circulate copies among the
Yes.
copies for the judges.
By Monday, my lord, it will be before
Fantastic.
your
All
lordship.
right, then CAB. আর কি? But Mr. Kumar,
My lord.
learned advocate who appears on behalf of the appellant in F83 of 2022.
I'm the respondent, my lord. I'm the respondent. Dr. Joy.
You said you are for Robin Bakchi?
No. Mr. Sivapalan is for Robin Bakchi. I am for Dr. Joy.
Mr. Sivabalan, where is he?
He appeared at the initial time. He's appeared. I think now he's not there.
Yes, he had joined.
Yes, he's joined. He's joined.
Where is he?
Sivabalan কি
ও তো সাপোর্ট করছে উল্টো সাইড কে?
Sivabalan তো রয়েছে ওখানে আনমিউট করে
লুকিয়ে আছে তাকে শুনতে হবে।
হ্যাঁ Sivabalan আনমিউট করে ইয়ে করে
কোথায় মিস্টার শিববালান?
My lord, I am appearing, my lord, but my link is not clear, my lord.
Doesn't matter. But Mr. Shivabalan, you are the appellant, Robin Bakchi, who was successful before Justice Bharadwaj's division bench.
Yes, my lord.
So what do you have to say now
On the reference.
on the reference, whether either of my brothers were correct while presiding those division benches?
What is your argument on that?
My lord, let it be not today, my lord.
No further time. No further time. Please argue. কিন্তু এক্সপেকটেশন দিচ্ছি যত তাড়াতাড়ি বড় করতে ওই জন্য ধরে রেখে দিয়েছি ওখানে সুপ্রিম কোর্ট বলেছে যে আমরা পাস করছি না
Because your appeal before the appeal by Dr. John before the Supreme Court is pending.
Yes, I went to Supreme Court.
And the Honorable Supreme Court has kept it pending, that appeal pending, because we have a reference here to answer and we have to answer it immediately. So what is, Mr. Shivabalan, you have to support the argument that the district judge does not have the jurisdiction, it will be the Calcutta High Court.
Yes.
So what do you have to say to that? Or having gone through the regulations and notifications, are you চলে গেছে এসছেন
কন্টেম্পট রুল ইস্যু করে দিলেই তো হয় সকাল থেকে কন্টেম্পট করে না না এটা স্ক্রিনে চলে আসবে
পেপারস গুলো সোমবার দিকেও দিয়ে
দিক আমরা দেখি
তাহলে বুধবার দিন আমরা একটা কম্পিউটার রেখে ছাত্র
So Mr. Shivabalan, when can you come? When can you argue?
Next week, any date, my lord.
Only one day, then we'll allow you. Okay, it's a short point. You just have to support your own, the decision of Justice Bharadwaj with vis-a-vis the notifications. কবে দিবি বল?
শেষ হয়ে যাবে আর সোমবার দিন মিস্টার চ্যাটার্জিও দিয়ে দেবে কাগজপত্র
সোমবার তো চ্যাটার্জি দিয়ে দিচ্ছে
বুধবার রাখবি? বুধবার
বুধবার কি তারিখ?
17 বাবা।
17
3:30 4টে বেশি তো কিছু বলবেন না
24 তারিখ করে দে না
24 তারিখ করবে লাস্ট দিন
তারিখে বাই চান্স
লাস্ট দিনে 24 তারিখ
23 তারিখ
24th
24 থাকবে
না
No, my lord.
Next Wednesday, Miller is fine. Any day, Your Lordship, please. Next week.
What are they?
3:30 করবে
3:30
Yes, Mr. Shivabalan.
My lord.
Shivabalan.
My lord.
Learned advocate for the learned advocate, Mr. Shivabalan, learned advocate for the appellant in FAT3 of 2022 has entered appearance. He requests for an accommodation. Let this matter appear on 17th at 3:30.
Highly obliged, my lord.
The learned counsel for the appellant in FAT4 of 2025 will submit a compilation of the relevant documents and regulations, regulation notifications.
Whatever documents were relied upon, we'll make a bunch.
And Mr. Chakraborty, just help us out in this.
Thank you.
Yes.
Lord, I saw him in court one day, Lord, and I said that my lords were looking for him.
No, actually, because he was
That's
the
why
person
he's-
part of the matter before me.
Take a short note now. Make a short note.
We can appoint him as
amicus. Mr. Shatadru Chakraborty is appointed as amicus curiae in the matter.
Mr.
My
Shatadru.
presence may be required, my lord. My presence may also be required.
take it now
Mr. Shatadru Chakraborty, learned, sorry, to me,
হ্যাঁ বল তাই
learned senior advocate, is requested to act as amicus curiae in the matter.
My presence may also be recorded, my lord. My presence may be recorded, my lord.
But Mr. Shivabalan, learned
What is your word?
I'm Vijay Kumar.
Mr. John.
Oh, John, Dr. John.
And Mr. Shivabalan, learned advocate for the has entered appearance ওটা হয়ে গেছে. Mr. Kumar submits on behalf of the respondent in FAT3 of 2022 Mr. Honorable Chatterjee has concluded his submissions. Correct. উপরে আমার কাজটা উপরে দিয়ে দাও।
এটা ওনার কাছে পাঠিয়ে দিই অর্ডারটা, উনি দেখে দিলে আমরা সই করব।
চলো।
Obliged, my lord.
পাসওয়ার্ড লাগিয়ে দিতে
Password item number 5.
এমনিতেই হবে না। None appears for the parties, adjourn for the day.
Password item number 6.
Same.
Password item number 7.
Same.
Password item number 8.
Same.
Item number 21.
People থাকো। 21 are appearing.
Lord, I am appearing for the Board of Wakaf Lordship. Lord, MD Salahuddin is appearing in this matter. Lord, he had minor surgery, my lord. He'll be back on next week, my lord.
So we'll keep it next week then.
Lordship.
Mr. Salahuddin is for the board.
Lordship.
Acha. An adjournment is none appears for the petitioners. Full stop. An adjournment is sought. This is a contempt application.
Lordship, this is contempt.
An adjournment is sought on behalf of the Board of Wakafs. Full stop. Accordingly, let the matter stand adjourned till December 19, 2025. Next Friday.
Great, Lords.
Item number 22.
None appears for the parties. Adjourned for the day. Sure.